matter, there are complete applications. The protected matter, my lord, day before yesterday, a copy of the rejoinder has been brought by my learned senior.
Lord, in the second sub-item, the two aspects of challenge. One, the retrospective application of the rules.
What he says is that you have served the rejoinder yesterday.
Day before. That's
So day before yesterday or yesterday?
Day before.
So why don't you go through yesterday?
But we have gone through, but I have sent it to the department. So
For what?
they have to say anything on that.
Sorry?
Other facts have come up, or
Some facts has been
Facts
also raised.
First matter can be, the other matter can be that. First matter is very simple. So it won't take much time also.
What?
The first matter, there are two matters on board. The first matter, pleadings are complete. We are also giving up.
they are not identical. Both the matters are not identical or connected to each other.
Originally, they were identical. Now we are giving up major portion of our press. So it's a very short point. It won't take much time also. And in the first matter, pleadings are complete.
Appreciate it, but the difficulty is once it is tagged, then the question would be that it has to be disposed of in one go.
I don't know whether my client to the state is objecting to the
But
first.
he must not have been prepared.
Sir, in the second
Both the
matter,
matters.
In the meantime, if any reply is required, I'll file, otherwise.
No, and
Matter
just
will be
reply
to a rejoinder.
Why this we are giving
If
up?
at all required.
Why it is never heard of the reply to a rejoinder?
If it is required, otherwise.
But
because
even if we will not grant you a leave,
Fine.
even if it is required.
I'll just go through that rejoinder
But,
because
but-
it has been served very day before yesterday, so.
For his benefit, I want to say that the major prayers that we are giving up. Only amount is the amount we wanted to be refunded because the rules have been actually brought about prospectively. They have made it applicable retrospectively, for which this amount of around very small amount also is lying with them.
and I have an additional point in the impugned order.
That is the second matter
The
of
second.
second matter he wanted. He wanted
First matter.
First. I
First
have an
matter.
additional point in the second.
what you have said. That he's giving up all his points except a few amount which you have kept. He wanted it back.
And only applicability of rules.
This
Only
motion is
applicability of
being made
rules.
today only.
Yes, yes.
Otherwise, they have challenged the virus of the statute.
No,
that
understand.
mineral auction rules.
They are giving up.
So if they are giving up, then I'll have to.
No.
What
so
will
far
have
as-
to?
So far as his claim of retrospectivity,
Yes.
that is the only issue he is raking up now. Are you ready with that? That is what we are.
But
That point only.
That
He is confining his argument to that point only.
But-
Applicability of rules retrospectively or prospectively. That is the.
Yes.
And if it is not retrospective, then he is entitled for refund. That is what his sum and substance I could understand.
My
So,
yes,
respectable
yes.
submission, my lord, the letter of intent which was issued in favor of the petitioner, that was revoked, keeping in view the statutory provisions. That is the mineral auction rules, amendment brought to the mineral auction rules in 10(6)(a) and 6(b) in 2020, which they have challenged. They have challenged the virus of the statute as well as the.
Where is this order of 28/4/2021 which you are challenging?
that is at page number 216. Page 216. Annexure 28.
20.
PDF page 261 and the physical copy page number 260, annexure 28.
So the main focus is on this.
Main focus is now, if your lordship sees the operative portion at page 224, that is the internal page 9 of.
No, I understand. That is what they keep this 3 crores, 4 lakhs and all.
3 crores, 4
And-
lakhs into goes. So that would be around roughly the amount involved is 6 crores. 6 crores odd. And the basic point here is that
So you wanted this money to be back.
my lord, That's the only thing. Prayer number A, we are giving up. Here, the tender was floated on 6/12/2019. An e-auction happened, we deposited. On 23/2020, that's almost 3 months after the tender being floated, they come about with a set of rules saying that you have to execute the mining lease within a period of 15 days. And if you don't execute, the entire amount will be forfeited. These two rules came about after the tender was floated, and invoking this clause, they have taken away our money. Original period was 3 years. So from 3 years, which was there at the time of floating of the tender, that gets curtailed to 15 days. And basically what we are saying is you cannot make these rules retrospectively applicable. That's one. Second is now we have a 2025 judgment. All this happened during COVID. So COVID-19 extension would also apply. IBC, they have made it applicable. So also would come in. So I have two submissions. One is you can't make this applicable retrospectively. Two is that COVID-19 pandemic order would also apply. In view of that, all that I seek, my lord, is give me back this 6 crores odd. Let the mines go to Vedanta, which has been awarded. We are not concerned. I also give up my prayer number A regarding mines.
Now what you say?
There is an explicit clause in the rule itself that the rule has to be applied from a particular date, which is prior.
It has
to
been
issue.
given a retrospective effect.
Yes.
Where is that?
There is no retrospective effect.
No,
He is saying that the rule says that it will apply. Where is the rule?
We are giving hard copy.
Well, I have an additional submission is Item 2. In the impugned order, one of the sheet anchors of my submission is he who hears must decide. That is violated. So principles of natural justice is the additional submission in my application.
Show me which provision says that it will apply retrospectively.
Unless the amendment is at page 617 of item 2 otherwise, the second matter which my lords are taking up.
But we just the English version is of page 2. The date of notification is 20th March 2020. 20th March
They
2020.
shall come into force on the date of their
Publication of
publication.
the official gazette. And here the tender was floated on 6/12.
Where is a retrospective effect?
And the rules have been quoted below that.
The rule is rule 10.
Mr. Das, show us. You said that it will be a retrospective effect. Where it is said? Rather the subsection 1. The rule sub-rule. Now this is the act or a rule. The sub-rule 2 says it will come into force on the date of their publication in the official gazette. Prospective in nature.
I have got my lord has dealt with this on several occasions. I have got my lord's judgment and those two Supreme Court judgments, 2021 and 2015.
What do you say, sir? How can you say that it has been given from a retrospective effect?
6A and 6B below that, they drastically reduce the time from 3 years.
No, I have seen that.
Lecture 3/2 to be counteracted. In fact, I was referred to this level. The amendment bill.
Where it is?
Section E/2.
E by?
E/2 to my counter affidavit.
Where it is? I do not find it.
Page 44.
That would be
269 on your lordship's bill.
PDF page would be 314.
That is bill, sir.
Sir, that is a bill. But what about the notification, the act?
How can you refer this in a counter? This is mineral laws
Sir,
amendment.
the bill was simply presented or placed in the floor of the house for its approval or the concurrence. But when it is transformed into an act, then the act will prevail and the bill will not have any.
So here also no, it's not
Either another.
This is act means this is subordinate legislation.
This is act, sir. That is mineral laws amendment. This is something different. You are misconceiving, sir. It is Mineral Laws Amendment Bill that has been converted, that has been enacted as Mineral Laws Amendment Act 2020 later on. But we are on rules, not on act. Rules, this sub-rule 6A, capital A,
Yes.
to rule 10, 6A, that has come into force with effect from 20th March 2020. When Corona was at the peak, just in inception. So from 15th March 2020, the extension.
Extension being.
Yes, ma'am.
So till May 2020.
Now, my lord, even 15 days, because this is the rule, I cannot dispute, and it takes effect from the date of publication in the Gazette.
Yes.
Now, you lordship may kindly see when it was published in the Gazette. That is on 20th March 2020.
That's right.
Yes. Yes. My lord, the letter of acceptance which was issued.
I am asking you when you floated the tender. What is the initiation of a process? By floating a tender or when the letter of intent is given? Tell me.
From 2019.
When you floated, what was the last date for submission?
The last date for submission, the petitioner submitted his bid on 30/12/2019.
So much before, knowing fully well that if the contract is awarded, he has to execute within 3 years. Can you vary the terms when the game has already been played?
But he accepted the conditions of the letter of intent only after commencement of the rule.
I am asking you, sir, by virtue of letter of what is the subordinate legislation? The act does not say that it has to be executed within a certain time. Act is silent. By virtue of a subordinate legislation, you incorporated a time period. Yes, pursuant to the act, you have to execute it within certain time because it cannot remain perpetually open. Now, they know very well because that was a rule which was prevalent. Now you have suddenly reduced it from 3 years to 15 days. And then say, I operate, I hereby, because letter of intent I'm issuing after 20th, 20th March 2020. So 15 days time. This is.
Even sir, letter of intent is 18th March.
18th March.
So,
Oh my God.
Before that, I mean.
I have not.
no, I'm just saying
That is what I advantage with my brother.
He's turning it to letter of intent, even if we accept it.
Yes.
It is prior to this.
Yes.
Not on
What
the
I'm saying, my lord, the letter of
that
intent.
is unilateral act. That is unilateral act.
No, not a unilateral, right? Letter of intent was issued on 18/3/2020. The amendment came on 23/2020, and acceptance of the letter of intent was executed on 23/3/2020, which is after the commencement of the statute.
Show us one law. I will be surprised with this law, Mr. Das. I will be very happy if you can cite one law,
And
one decision.
and moreover, my lord, when he was after the commencement of the statute, when he was asked to submit the upfront, the 10% of the upfront of the first installment, he deposited. For second, he sought for time. Extension was given on his request for execution of lease within the time frame. He did not.
Sir, by then Honorable Supreme Court judgment.
So by his action, he has acquiesced everything, including the provisions of the statute.
You have forgotten those days, Mr.
And
That's
he made a request to the authorities that kindly
Show us that the principle of acquiescence will override the statutory rights.
No, that's one part. In the second sub-item, all this does not hold true because in my case, the installment was deposited on 25th of February 2020. And I did not accept the LOI because the goalpost changed.
Show us any judgment in your support. Because what I understood is something different. First matter is they are not challenging that the virus, they are not saying.
Today,
They simply says that yes, the law has come. I am not saying anything. You are competent to bring that law. You have brought that law, but only thing is that you'll have to implement the law, either from a prospective date or from a retrospective date.
but that
So their condition is no retrospectivity is attached. It is very clear from this particular notification that it will come into effect. Now the question is, when the acceptance of the LOI comes, whether that would be the crucial date for consideration that which law will apply. Show us any judgment.
I'll answer on that. But today they made a submission that they are not going to, their major portion of their prayer, they don't want to.
No, it is not he, but he, the first matter,
In my language.
where all the pleadings have been completed.
Yes.
He is saying that now my matter, the pleadings are complete. I do not want to argue on a virus. I abandon that particular claim. I simply argue on this particular proposition of law that you have forfeited it. You have blacklisted them. You have said that you cannot participate in the future. Applying this particular rule, which came in existence on 20th of March 2020, according to him, it should not be given effect prior thereto, or anything done prior thereto. That's a very simple argument which is there. So where is because this was also one of the ground here. So you are ready with that matter. First matter, you are ready. Second matter, you may not be.
But that point has been raised just now.
Yeah, unnecessarily.
To answer that.
No, Mr. You should come prepared in this regard. They knew it very well. You can't show so much of.
Just now they are saying that they are dropping their prayer with respect to the virus.
But these were prayers there. They may abundance if they have sought 4 release. They say I will not argue on 3 release. I will argue on 1 release. But you knew it that this matter involves 4 release. So you are ready with all the 4 release. You are ready with all the 4 release. Suppose if they do not abandon, you can't say that I am not.
But if they do not abandon, then the virus of the statute comes into play and the central government has to answer those queries because that is
So
the
it's not
option.
required. They say no. It's a very open. It's not.
Plain case.
It's a plain case.
Then if we accept his argument also, that after the game is commenced, the subsequent things cannot have any repercussion on the.
Well, in second case, even with your lordship's permission, I'm also confining myself only to the first claim. Because for me also the option has been held. And I did not participate in the subsequent option. So I'm also confining myself only to the refund part.
Prayer A and prayer D, my lords, where we have said that prospective operation of the rule. That's all. We have the alternative prayers we give up.
And rules, see, if any rule or even statutory provision which imposes extra burden on the citizen or the necessity or the payer, then that cannot be retrospective. Even in taxation matter, JML2 and ALD, reverse burden was thrust upon the dealers. Honorable Madras High Court upheld the virus retrospective. Honorable Supreme Court confined to.
Here no reverse order was put on the.
There is no burden.
Here only the
What
timelines
is this?
were fixed.
Where is the 18?
Only timelines were
18 March.
It matches.
Page.
Uh, 157.
Bring 147.
Mr. Mishra is 147. Letter of intent.
My lords, second matter 653, my lords. First, second matter 653.
One 47.
No, 145 is continuation of offender. 147, Annexure 2.
Nature to 147 is the letter of intent. You have also given a clean copy. You can also not taking clean copies of that one. Copy is also at PDF page 387. Simple point here is that at the time of bidding, I never knew that they'll come up with drastic reductions. That amounts to changing the rules of the game after the game has begun. And these clauses of forfeiture and debarment were also not there originally. So 6A and 6B have been introduced much after bidding and after my prices have been accepted. So in tender matters, this is simply not possible. And now they have given these mines to Vedant. We are not challenging that. All that we want is you give this amount which is lying. One is protected by.
There is another impression which I have gathered, subject to both of you what you say, that this makes more strengthen the concept or the notion of a prospective operation. If you look at the amended provision, that is Rule 6A, which you introduce, is starting with a non-obstante clause, talking about the execution of a lease deed within 15 days from one is the date of issue of letter of intent to the new lessee to whom the vesting order has been issued under 9A. To the commencement of minor auction amendment rules 2020. 3. The expiry of lease period, whichever is latter, not the earlier. Had it been a retrospective operation, they could have called it a earlier. Why they call it a letter? Reason being that the letter of intent, if it is issued after the amendment, then from that day 15 days will be counted, not from the date of commencement. Had this 15 days be there, then it should have been an earlier.
My lords, just to add to that, my lords have held in various judgments that subordinate legislation cannot be retrospective. My lords, from Hukum Chand onwards, my lords have seen that unless the act gives power to make retrospective legislation, subordinate legislation will not be retrospective.
That is a very, very fundamental, I think the first golden principles of the interpreting any legislations which comes before the court. It is always regarded to have its operation in prospective manner unless intended by a legislation to operate prospectively.
So, my lords, even my lords, I completely bow down. So, in this case, my lords have tested that under MMDR Act, there's no provision to make subordinate legislation.
That is what I say. This is only in the rules, subordinate legislation. Mr. Das, no, we don't think so. You want to gain time, that's another aspect. That is a different aspect, but I do not think so. The law is so settled in this regard. I do not think. What do you want to do? What you will do?
Well, even going by the rules, the
Yes.
provisions contemplated under the rules,
Correct.
they were given extensions as per their own request.
True.
And to that extent, they accepted the conditions under the rules, but they failed to execute. Now,
Execute within what time? That is the main crux.
within the time of beyond the time of 15 days.
I am asking you, sir, if the 3 years period was initially provided, if you have granted an extension of time, then in that event, if in the meantime the pandemic has struck, the Supreme Court has already extended the period of limitations, the period of even a compliance under the statutory provision, suspended such operation, then how can you now say, and when you have terminated or forfeited?
We have only revoked on 2023. Order of revocation.
So the second installment was deposited by you.
Second installment was deposited on 31/3/2020.
So that was extended time.
That was extended by some period.
Yes. So
It has come, you have said correctly
Hmm.
later. This has come with effect from 23 to 2020.
correct. That
20.
is correct.
And
It has been issued before that.
Before that.
I'm just saying that. That is what I'm saying.
I'm just supplementing, sir.
Huh? Otherwise, it would not have been. So the second clause will come if the letter of intent is already issued.
Revoked during COVID only,
During COVID, 21,
And 21.
February 21.
not 23.
10 to 21 is my record.
Because
How can you do it, sir?
Everything happened during
During
COVID.
COVID.
15th March was the date.
And when the last order was passed extending the period,
No extension in my.
Supreme Court judgment I'm talking.
That is first January 10th January 2022. Their lordships have.
No, 3 months
90
period
days.
from
That's right.
So May 29, 2022.
2022. So we are much. This is
Within
not
that
one of those borderline.
yes.
With much within that.
Once it was withdrawn, thereafter again claimed
Yes.
retrospectively.
Yes. In fact, I have given
From
one
15th March 2020 till
this
May
judgment.
May
2022, the entire period was covered.
2025, they have, while extending up to IBC, they have clarified all of this. And IBC, my lord, knows is 90 days is statutory. That has also been extended. My lord may just see paragraph 35 onwards. It's at page 587 on the right hand side. COVID-19 pandemic and its impact on limitation. That's the heading.
He's absolutely handicapped. He is not ready at all. He is not ready at all.
Now you could, this is the short point with, this is
They want
by
record of their-
Mr.
Yes. Yes.
No, what they want is that the letter by which you forfeited their amount and by, in this case, imposing some kind of a debarment from participating, that should go. And the second one is now, once you have decided to go for a fresh one, so let them be refunded. That's it.
But the performance security was never deposited by the petitioner.
Whatever, because you have already cancelled it where they will.
Well, it was cancelled because it was not submitted within the time frame.
Sir, that time period, the mischief period, that period was under the garb of that particular Supreme Court judgment, where the extension was granted. If that being the position, will you take a plea of the time?
Once the acceptance of the letter of intent, not only acceptance of the letter of intent occurred after the statute came into force. Yes, my lord. The vesting order by the state government was issued on 4/6/2020.
Can it be? I'm asking.
But that was accepted. They didn't dispute that. Your Lordship, I kindly see.
What is this vesting order?
On 17/6/2020, an email is received from the petitioner that please grant us some extended time so that we can execute the lease.
Because
Time
COVID,
granted.
major management is under COVID.
Time granted.
the time means if the period is 3 years, even if somebody under the mistaken advice have written a letter for extension of time to execute, can you now say that I will not extend the time when the normal period within which the execution is to take?
Has extended as per their
Mr. Das, probably, I am unable to connect my wavelength of mind. Is it true that prior to this amendment, the maximum period for execution of the lease was 3 years? Tell me, I have not seen the document. I'm asking you, is it true? Which by this amendment has been reduced to 15 days? Tell me straight away. Sir, you have taken. Where is that 3 years period?
That there, in the tender itself, and the
Auction rules 10(6) proviso. Provided that no mining lease deed shall be executed on expiry of a period of 3 years from the date of letter of intent, and the letter of intent shall be invalidated, leading to annulment of the entire process.
So
of auction.
this provision is there. Then
Yeah.
why the extension is sought?
Rule 10
Even if it is sought, it is absolutely, I would say, the surpluses.
provided further that the state government may allow a further period of 2 years from execution of the mining lease deed if the reasons for delay were beyond the control of the proprietor.
What more?
That is
That is
That is
another
after
contingency,
execution of the
the
lease.
contingency, which is extracted at page 11 of the
What?
petition,
What?
that is auction rules.
No,
Auction
no.
rules 24.
May allow for the period of 2 years, what it says?
Provided further that the state government may allow a further period of 2 years
For
for
execution.
execution of the
Correct.
mining
That
lease
means,
deed.
that means maximum is 5. No, sir, this can't be.
and so far as performance bank and we have given it interim order dated 7/5/2021 protects us, saying that so far as bank guarantee towards bid security furnished by the petition amounting to 3 crores 4,80,000.
No, third party interest has been created or what?
Yes, it has
the
been created.
time it has been created, madam.
Through an auction method, so no loss to this claim.
So that
We
is
are also not.
take instruction from the authority.
So this interim order is still alive, and we are keeping this bank guarantee renewed even today. Order number 2 dated.
Regarding this matter.
So the order
On Wednesday, next Wednesday. we'll Take instruction.
Unnecessary. What instruction? That is the, I fail to understand.
Instruction.
The instruction on a proposition of law,
Now,
that creates a problem now.
now they pray that the major part of their
Sir,
prayer
that is
they-
what is the game in the court. Order 23, Rule 1 permits abandonment of whole or a part of the claim. Now they say that I hereby abandon a part of my claim. देखिए, you should be ready for the entire claim. If they have abandoned a part of the claim, that means
They are
you
only
need not have to bother for that. But you are ready for all. Now they say I restrict my claim to this one. And for that you need an instruction from them. Not appreciable. You know the nuances of law. That's all. This is a pure question of law.
regarding the refund, I just
Refund is not that. Refund is you have already created a third party interest. the refund is only on the ground that you are taking shelter under this law, whether this law has any retrospective operation. That's all. There's a pure question of law. What the authority will say, it will all appear from the different languages or the words or the expressions used in the statute book. That's all. Nothing more than that. I leave it to you.
We wanted to simplify it for him. Very small.
Let
amount
my
of
brother
space.
take a decision what to do.
Now he could understand, let him come prepared.
I gave it up out of fairness to
On
them.
Wednesday, at this,
But Wednesday, I think that other batch matter is
no,
posted.
you will confine to.
Same.
Just let him be prepared on those.
I would like to. Same with that. I'm also confining myself to prayer A.
Prayer A and C.
Again,
I think D, sorry. Prayer A and D.
He is appearing along with you.
Can I
Hello.
request my lord,
Another point is.
Well, another point is, well, in the impugned order, the show cause notice said that the special secretary would take up the hearing. The special secretary took up the hearing pursuant to your lordship's kind intervention. And the order has been passed by the joint secretary. So he who
Or he
hears-
is directed to communicate.
No,
He passed the order or he is directed to communicate the order.
the joint secretary has passed the order. I'm very conscious of the fact that he was not directed
No,
to
I'm
communicate.
just.
So he who hears
Sometimes
must
it is
decide.
I know. It's a communication of the decision of the.
It is not a communication. It's decided by the joint secretary. It's subordinate authority.
Again,
Gulapalli
Gil.
Nageshwara.
That record I cannot also improve with my argument. Because that is all.
then on these 2 points,
Yes.
he
these
has 2 points. And he has
Now
one
you
point.
understood that if you take an instruction on a legal point, I would be happy to take an instruction on this one. Take instruction from them, what they say. I leave it to my brother, whatever he decides, I don't know. Then it is up to you what to do.
Wednesday, Supreme Court, I haven't. Can it be on second Tuesday?
No,
I know your lordships have planned.
we are not
this.
taking up that on next 10th. 9th
Third on next 10th. 10th is Wednesday.
or 10th. On
As
10th.
your lordship please. As your lordship please.
On 10th.
10th December.
Then let it be on third minutes. I will appear in VC. Let it be on third.
Your lordship has fixed the
Because
batch mining matter.
This is a short point. I don't
No,
think.
that
No,
hearing.
that's why I said
But
it is
let it
in,
be on third.
it is fresh in the mind,
Unless-
and we have already
Yes.
prima facie
Given
we have examined along with this.
Those judgments regarding retrospective applicability, I have given those judgments for convenience. Let it be on third man.
Let him come.
With your lordship, please, I'll appear on this in VC.
There will be. Third.
Third, request for orders in position.
Retain the same position.
Same position.
The interim order passed earlier. Kindly continue.
Interim orders.
In both cases.
Both.
Item number 2.
They're great for the.
Why for admission today is a hearing date. So why admission?
Well, that's the interim orders to continue because those orders were till today.
It is exception. It will come from Supreme Court. Once readings are complete.
Oh.
It is. I just have I don't try this. I don't something.
People.
It's a 2010 matter.
Today is hearing day, sir. Today is hearing day. So,
Whole difficulty, Mr. Sandeep Math is inadequately engaged in this case. There are some personal difficulties that we can be taken up on third week of this.
Who?
Mr. Sanjeev Mahan. Inadequate. He has been in his there in this case. So there's some personal difficulties and it's on third week of December. He'll be out of. Can I pray for him?
These were all mentioned matter. These matters have come up.
I mean, it was mentioned, not reached with them, when it is published in the on Friday, it is published in our office.
Yes. Whatever.
on 10th.
After 12th, we'll be back with you. After 12th, it will be.
17th.
Madam.
Item number 3.
At the request of Mr. Rakesh Sharma. As the senior counsel.
Yeah. Various tender was quoted for construction of the road. Petitioner in fact completed the construction, now it is over, handed over, final bills were paid. But after he took over, after the estimation was done and he became the lowest tender at the
Just give me 30 seconds time. I'm just perusing the order dated 5/8/2022.
Sir.
So this was recorded that they have taken shelter under this clause 7.1 and 13.4 of this SBD. What is this?
7.1.
What is this SBD?
Standard bidding document.
Standard bidding document. And then the court has recorded the 7.1 relates to site visit and 13.4 deals with the price quoted for the sand.
Right.
So it says that both the issues are not connected with
the claim that has been raised, the price variations.
So in that event, where is this 7.1 and 13?
Yes, sir. Looks at 7.1, page 38.
Page
38. Says site visit.
yes.
The bidder at his own cost, responsibility and risk is encouraged.
So these are the conditions that you will visit the site and then later on you cannot make any representation that it has not been done.
Here actually that's not the case.
Then 13.4.
13.4, lordship turns to page 43. The rate
Shall be fixed for the duration and shall not be sand price quoted, will not be varied.
right.
Now, just wait, madam. Let me first understand the point. I have not read the brief. I have read the order. Now I have gone through these two clauses. Please, where is the letter which you are impugning by which they have taken shelter under this and rejected your claim?
Rejected word if lordship turns to Annexure 796/2022,
Page.
page 49. If lordship turns
97.
97. Annexure 7, page 97.
No, 9. Achha. Yes. Earlier the matter was heard
It was heard with us.
because lot of
Yes.
by us or somebody else.
Yes. Other.
Just give us just 30 seconds time. What was your representation?
The representation first comes to page 90, madam.
90.
Yes, madam. 11/1/2022.
Too weak. What is the meaning of the word minor minerals in your representation?
Yes, madam.
What is the meaning? It also comes within that. It comes the sand comes within that minor minerals.
But here it is, 4 things are there.
No. You simply said that you were supposed to lift it from that particular mines,
Yes.
which got closed.
Query.
Now you are
Query. It's a query.
mining activities. You were just saying yes.
Fine.
Yes, Kupari.
Upal.
Now you have to take it from
Charidhara.
Charadhara, whatever, which is 80 kilometers from the side. So you say that this differential amount, the transportation.
That was raised, that I have to complete by doing a higher, longer.
Where is the escalation charge price? Where is the escalation clause?
Sir, that is clause 35,
Page.
page 73, variation clause. Page 73.
Clause, this at the bottom.
35 bottom.
That was in fact a mercy petition from your side.
But if you are, I kindly appreciate one, can you look at page 84 of my additional affidavit? Additional affidavit, 9/4/2021, remember, 21/8/2023 it was filed.
Black.
Additional affidavit. Like the page. Yes.
Page 118.
Huh?
108. 118.
Yes.
Page 84. This document I got in right to information, that's all. But
This one?
so the estimation was made.
No. Which you are talking about additional affidavit.
Yes, sir, excellent.
So where is which document you want to rely?
And sir, it is Annexure 9.
Nine, that is a detailed estimate and land statement.
Sir,
Where is the annexure 9?
Annexure 9, page 71 of that additional affidavit.
71.
Yes, sir,
Chronicle 180.
of that additional affidavit.
$1.
It has not been paginated along with the read through.
Page 188.
This is. Which document?
Annexure 9. The running page 188 was to
Yes. Yes.
and page 84, the running page 201.
Yes.
The estimation of price for execution of the work is an internal document. It was not provided to the contractors.
Yes.
From Kupuri mine. Name of the query if you are still looks at.
Where?
That is 9421. Kupuri mentioned. For 942021, it has been done by the engineers. The next page.
No, page 201.
201.
No.
Lead statement,
Yes. Lead state.
lead statement.
Yes.
Name of the
Where is the lead state?
lead statement for plant mixed materials.
Yes. From where I get it, Kupuri?
Name of the query is Kupuri.
Oh, this one. Okay. Yes.
All the materials. Next page also the same thing. Different query purpose those materials are available in Kupuri itself. But Kupari mine. So this was in fact when the estimation was made, Kupari mine had already been closed because of the NGT order. So the estimation made on that basis is less amount because of this. Now I brought it to the notice immediately after I came to know that kindly see I have to go for 80 kilometers more. So this differential price on regard to the transportation I am required to pay. Nothing more. I don't change anything else.
Yes.
And the stoppage of NGT order is also there if your still looks at.
No, that's true. Then that's all.
Two clauses of the tender minutes. First could be clause number 7 at page number 38, my lord.
7.1.
Yes, miss, that is
Yes.
site visit.
Yes.
Only one line from that portion, which states that the employer makes no representation whatsoever at page number 38, express, implicit or otherwise regarding accuracy, adequacy, correctness, reliability, and or completeness of any assessment, assumption, statements or information provided by it, and the bidders confirm that it shall have no claim whatsoever against the employer in this regard. Well, my lord.
No. What do you mean by this? Please read. It was in relation to a site visit.
Yes, ma'am.
Site visit means that before you participate into the tender, you'll have to go and visit the site, and you should ensure that you have already taken it. And when you quote the price, then thereafter you will not say that this site is somehow not appropriate. It's being there has been a lot of hurdle, the obstacles, all these things. The boulders are coming there. We have to remove the boulders which are there. I can't make it. All these things were there that you cannot raise this point that there was some defect in the site or something of that kind. They did not say so. So that is not their claim. They never projected that there was any difficulty in execution at the site.
This provision is very wide enough to include everything.
Sir, the head note has to be considered before the court proceeds and decides everything. You can't segregate it. Had it been an independent clause, I can understand. But once it comes, that means any correspondences, any kind of a things, anything which relates to a site visit that will not be entertained.
Because it means local conditions, madam. Local conditions.
So that is what I'm saying. Local conditions means when he's executing a road. I think you're making the road. Local conditions, the local have peoples are coming and objecting to it. That cannot be a ground for them. They are debarred from doing it.
Second clause 13 at page number 42, madam.
Sand.
No, madam. Bid prices. What is bid price, madam? The contract shall be for the whole work.
Which one? You have cited 13.4. You have not cited any other clause.
Madam, I'll come to 13.2. There is a misreading of 13.4, madam.
You wanted to say that 13.4 has to be correctly. Which one?
Page number
40?
madam.
Yes. Yes.
Not rates and prices. This is rates and prices, madam.
What?
This is rates and prices.
Sand is?
It's not sand, my lord. It is rates and prices.
But this document you say is a wrong one?
Hand price.
No, it's typographical error. I have a standard document, my lord. It's that same.
No, this is what,
This is not rates and prices. This rates and prices quoted by the builder shall be fixed for the duration of the contract.
is there any clause in the tender that they will quote the sand price separately?
Look, that
Show me. Is there, while quoting the price, they have to also quote the sand prices?
13 minutes, page 42 minutes.
No. What is the price? What is required to be quoted?
Everything, it's bill of quantity contract mileage.
Please, I'm asking you. What is required to be quoted? Is there separate price for sand?
It's 13.2 mileage. Item rate method require the bidder to quote rates and prices for all items of the works described in the bills of quantity mileage.
Where?
Page 42,
Yes.
13.
Yes.
13.2, third portion mileage. The item rate method requires the bidder to quote rates and prices for all the items of the works described in the bills of quantity.
Where is the bills of quantity?
This does not have mileage. This document, the annex.
No, there should be a bills of quantity described, works contract described in the bills of quantity. Where is that?
The document mileage does not have, but it's mentioned at page number 73 also, mileage. Clause 34 bills of quantity.
Yes.
This, if I may refer to page number 74 also, my lord. It's
No, I have seen payment for variation.
Yes, ma'am.
I have.
State contract. My lord.
No.
Yes, my lord.
I do not find that certain items are kept outside the variation clause. 36, which you are referring, is an exception to 35. 35 permits the variation.
Yes, my lord.
And 36 says that these items will not come under the variation. Anything which is outside will come under the variation.
Yes.
Again, I am talking about the bill of quantities is referred everywhere. If you have quoted the bill of quantities, what is described, then it will not come under variation. Now, question is that whether this was really quoted as a separate head, as a in the bill of quantities, because their case is that they are not quoting anything separately. You are said.
Their case is not that, my lord. Their case is that now the Bukari is upon which they had made the
So these are
escalation,
transportation charges. That's all variation.
that charges has increased, my lords.
So they wanted that the transportation charges has increased. So this comes under the variation. Please consider it is not included in the bill of qualities or the quantities. It is not included because they have not quoted it separately. It is something beyond the bill of quantities or qualities, whatever. That's why I asked you show me that bill BOQ.
And that counter also doesn't say anything other than that.
No. He's saying a minor mistake has come.
That and
The S which should be attached or suffixed to E has been prefixed to A. This is what they say.
Yes, my lord, because whole
and even I got another copy also in additional evidence file.
well, I also have a copy which mentions rates and prices, my lords.
In the bid documents, if you have.
Yes, my lord. Same, my lord. Standard bid document of PMGSY, my lords. Same 13.4, my lords. And specifically says, my lord, the rates and prices.
But then why variation clause?
But variation is only with respect to the quantity substances which are not mentioned in the bills of.
I am asking you, that's why I am saying whether the transportation charge for carrying the sand or any minor minerals is quoted in the bill of quantities. No, separately.
No.
If it is no, then clause 35 has to be accepted. 36, which is an exception, is excluded. No, madam. No, madam. This can't be. We are not concerned whether their claim is genuine or not. I am again saying we are not concerned whether the genuine claim is there or not. We are simply concerned whether the rejection based upon 7.1 and 13.4 can be sustained. That's all. Whether you have applied these two provisions to clauses correctly. That's all. We are not concerned. We will not say anything on their entitlement or something. We will definitely say that whether it comes within 7.1 or 13.4 or not.
The bills of quantity includes everything, my lords. My lords, if I may read 13 once more, my lords.
Sir, madam, tell me that described, the word is described in the bill of quantities, BOQ. Where is that description? I just wanted.
13, I'll read once for my satisfaction, my lords.
Yes.
Page number 42.
Yes.
The contract shall be for the whole works as described in clause 1.1 of ITB, my lords.
Correct.
1.1 of my lords.
On the priced.
Bills of quantity submitted by the bidder online, my lords.
True.
The bidder shall make online entries to fill percentage rate or item rates in the bills of quantity as specified in the appendix to ITB.
Correct.
Only the same option is available to all the bidders. The bidders is not required to quote its rate for routine maintenance.
Yes.
What is not required is also mentioned, my lords. The rates to be paid to routine maintenance by the employer are indicated in the bills of quantity. So these are not mentioned.
I just wanted the bill of quantities where it is. It must have several subheads, several columns that you'll have to
That is not
fill up.
That is not a next.
That is what is. You are taking something new.
This is what
You are taking something new.
And your counter also at
Nothing has become. In the counter has said that this 13.4 is a typographical mistake.
Page number 103 of the counter, we specifically quoted mentioned the 13.4 malus. Page 103 of the running page malus.
Yes.
Clearly stipulate the rates and prices quoted by the bidder shall be fixed for.
No, where?
No, you are not stated anywhere that it is erroneous.
Where? I just wanted to know. Where you have?
Page 103 malus top.
Yes. Yes. But you have not said this is a topographical mirror.
There's a standard document. There is in the writ petition, they have added a word of malus. In the writ petition to quote.
Then why is this variation?
In typographical error malus because
Who has
So
typed
have
it?
you said so that there is a topographical error?
improved order that specific line is quoted malus, rates and prices.
There may be a several documents.
It's-
If there is, can you not include any special clause? Can you not subtract some clause from the standard document? You can't. So depending upon the nature of the work for which you are invited. What are you talking about? Sometimes that's the general terms and conditions, sometimes the special terms and conditions are also incorporated.
And it's again, I will refer to.
No, sir. No, madam. This can't be. Whatever you can't deny, you have also relied upon this document.
Only to that if it reads as rates and. prices.
But again, I am saying, suppose if we accept, then what is the purpose of clause 35? That's all. I just wanted. Then it has no meaning at all. And if there are two clauses which runs counter to each other, then which should prevail, the previous one or the latter one? On an interpretation of a contract, madam, tell me.
Only because it's a bills of quantity contract malus. The rates are fixed contract that is
I
specifically.
understand if something is beyond the bill of qualities.
That is for
They-
the bidders to quote malus. At the time of bidding, everything has to be.
What is to be quoted is that bill of quantities says that these are the items which they say. They will quote the price of a sand, that this is what the price of the sand is. Nothing more than, which includes that whatever the transportation fees and all, everything, whatever they are there. Subsequently, they found that the transportation charges for bringing the materials has increased because one of the mines which you said that you will collect it from there,
That is internal document.
whatever. So internal document has to be towed off and should be thrown in the dustbin.
Kupari was closed on 2019, ending of 2019, prior to the bid malus. The Kupari.
Then why you have included it
Estimation.
That's.
while taking an estimation?
That's internal document.
That you knew it, that this is what you estimate, that if they collect it from there, that will done. So they are saying you have to apply your mind, whether you will grant a variation, you will not grant a variation, we are not going to say. But we will certainly test the decision that whether the clause 7.1 or 13.4 was correctly applied.
And these documents are signed by superintendent.
But everything is signed.
Each page is signed by
All are signed.
superintendent.
Mistake.
Then 13.4, if it mentions rates and price, it does not make any sense, malus.
That's why I wanted a bill of quantities, whether it contains a particular specification of sand price. If it contains, then
The rate of the sand has to be prescribed by the bidder malus, including everything malus. For example, malus.
and you are showing us 13.2. Madam, when you cite any provision, then you can't shy away from there. It is a double-edged sword. 2 says that he has to quote item-wise. Item rate method requires the bidder to quote the rates. That means he will have to say that how many the stones he will use for construction of a road, how many cements are required, what would be the rate of the cements. These are the rates of the cement he will quote, taking into account the estimated increase or the decrease in the price. His own estimation. that I have to complete within 1.5 years, I expect that it may go high up to 10% of the present price. They will definitely take into account while quoting the price, 10%. There they cannot. Because if the price decrease, they will take advantage. So they cannot claim that the price has increased. I understand. But something which is not there.
Constructive reading of
Sorry.
13, my lord. Even what taxes
No.
are not to be included, that is also mentioned, my lord. What are to be included, that is also mentioned, my lord. So it is deemed that everything is included in the bills of quantity, my lord. If 13 is read as a whole, my lord.
I believe it. Again, what you are trying, you should have trying is say that when you quote a sand price, that includes the transportation of a sand from a quarry to a site. So it is an integral part of that. Then you say the sand price, if it is there, that will not be varied, will be fixed. Because it is one of the integral part of it. Now you say, no. It is not a sand price. It's a rates and prices. Even if we accept, then 35 or 34 has to be thrown out, 35 to be thrown out. Variation has no meaning.
Why? Variation is only with respect to bills of quantity which are not mentioned.
No,
Yes, my lord.
it is anything which is beyond the bills of quantity. Please read 36.1. Read it.
Variation, my lord, page number 75. 73, my lord.
1 clause 36.1.
Before that 34, my lord, bills of quantity is also explained here, my lord. Bills of quantity shall contain items for the construction, installation, testing, commissioning, maintaining, and lump sum amount per kilometer for yearly routine maintenance for each of the 5 years separately to be done by the contractor.
Right.
Bills of quantity is used to calculate the contract price. The contractor is paid for the quantities of the work done at the in the bills of quantity for each item for the construction of the road. The payment of routine maintenance of the road.
True, that is what I'm saying, that what is included in the bills of the contract, if it is varied, they will not be entitled. I am saying so, but whether this can be said to be included in the bills of quantity, no. The transportation charges for transporting the sand from a different mine which is at the distant, whether it is a bill of the quantities, no. Sand will be.
The materials used will be included in this.
Regarding transportation, if nothing is mentioned, then this going.
Then it is under the variation. Then a conscious decision has to be taken.
Everything will include transportation cost, my lords, because everything has to be brought from one place to another. So everything will include transportation cost, my lord. Now, because it is their inconvenience that it has gone further and they are suffering loss, that cannot be a ground for variation of the contract, my lords.
So take a decision. Who prevented you from taking such a decision? Again, I am saying the problem is I have been reminding from the day one the Supreme Court judgment of MS Gill. Every time I am reminding, but everybody is forgetting it. You are improving a case. Your authority has not said so. He has simply said that because of clause 7.1 and 13.4, I am not going to. There is a bar, ember, which does not appear to be correct.
78 Supreme Court clearly included.
This is what is consistently followed, except in between one judgment. That is from state of Bihar. There was some departure. But that was in a very unique and extraordinary, exceptional case.
Which means they have a dispute resolution system under the contract where they can approach if there is a violation.
Why you find our affidavit or counter affidavit?
The It's on.
Why you filed a counter affidavit? Why not at the very first day when the admission was made? You should have taken that, let them go there. I'm talking about Section 8 principles of the Arbitration and Conciliation Act.
That Malad,
So,
it's with respect to variation amount, because those are disputed
we
questions.
are not concerned with the variation amount. We are simply concerned that what he has agitated, you should decide it, whether you will grant or not grant, communicate to him. There is no difficulty, communicate. But not in this way. Yes, brother, will you write? This can't be done. Should I dictate or what?
Included in the bid document or not. Now it's page number 201, which the senior was referring. It refers cost and plus carriage.
Could be Roman. That is an estimation which you have done.
Yes, ma'am. This is the
Oh,
standard bills of quantity document numbers. So if this includes cost plus carriage, so what the petitioner must have submitted is also cost plus carriage. This is the only thing which I could,
consider it. It's not there. It is not a bill of quantities.
this is in the format of bills of quantity. ma'am.
No. It is an estimation which you make before you fix the reserve price.
That
So that is not a bill of quantities.
That includes bills, transport.
Whatever you use, take a stand, but you can't do it in this way. It is not a bill of quantities.
This is an estimate. ma'am. This is
Whatever-
the reference which I-
So why?
Because that includes.
Then I dictate.
That is the only thing.
No.
Which I thought, Malad, I would.
Then I should dictate.
Anything I could get during this week, Malad, that's fine.
That was commissioners.
Yes. Next matter.
I don't know.
The matter is becoming infructuous manner. The sole challenge is the order of debarment manner that is already over since June 2025.
Okay. Yes.
If there has been a debarment order, by the understanding. Order has taken effect, but the fact which is not going to be being an infructuous now. But with due respect, well, it has got far-reaching ramifications. That if the debarment or will not be blacklisting is ultimately an option finds to be illegal.
I just thought that he's for the petitioner.
Well, he's from the opposition party.
I understand. Now,
Well, in fact, I will be debarred from participating in any of the tender process for a further period of 2 years. Well, that becomes a disqualification, a stigma to my character as well as consultant. What should I kindly see, Malad? What should I kindly come to the debarment order straightway, Malad? At
Page?
as paid 162, Malad.
yes.
What should I kindly come to page 163, the relevant portions?
100 and
63.
yes.
Paragraph 7. Let me read from paragraph 6. However, upon the consultant's failure to submit representation documents even after approximately 1 month, the authority, via its letter number 216 dated 14th of February 2023, reminded the consultant for the submission of the document. The authority, via the same letter, further requested the consultant to submit the status of some structures work at site which was not found as per the certification. and recommendation of the consultant during the site.
Anyhow, they gave you further time to give you a
No
claim.
notice regarding the debarment was given to us.
Anyhow,
Well, now
Yeah.
actually kindly come to para 7. Further, during the progress review meetings of 17,
you admitted.
no, that was something different. The consultant admitted and reported that the excess amount of 27 crore has been released to the contractor as per the certification and recommendation of the consultant.
Then
But with this document they don't file in the counter. This document is not on record. That's the 17/2/2023 matter. Then Lordship will receive para 8. Accordingly, a show cause notice was issued to the consultant. Why did the authorities letter number 235 dated 18/2/23 and it was requested to submit its explanation within 7 days as to why disciplinary action shall not be taken against it for the lapses made in recommending excess payment of the contractor. In response to the same, the consultant filed its letter of 225 dated.
so it was not satisfactory. You gave a reply, it was not satisfactory. Cannot.
Statement taken particular to that notice, which is 18th of February 2023,
True.
at page 126.
Yes. Yes.
Well, now you come to page 127. Now, clause 4. It is observed that the authority's engineer has failed to comply with the above contractual obligations and made gross error while recommending payment of the contractor to the authority. Due diligence was not observed while recommending the contractor payment. In view of the above, it is requested to submit your explanation within 7 days from the issuance of this letter as to why disciplinary action, not in what nature not explained, shall not be taken against the authority's engineer for the lapses made in recommending the excess payment of the contractor. But this is the only notice. But this notice does not qualify, my lords, the mandate of law as has been laid down by the Honorable Supreme Court in ULC consultant case file. But you will just see that judgment.
So you are not an authorities engineer.
Well, I am the consultant engineer. It was the expansion of the National Highway. The principal is National Highway. The contract is Ganon. And I am the consultant to see the work. And then ultimately will give a recommendation as to whether work has been completed and payment will be made or not.
You are an authorities engineer or not?
Yes, sir. Yes.
So
And in
this notice was given to you, yes.
And Lord, may kindly come to the contract. What is the provision for the debarment or blacklisting? Lord, you kindly come to page 73. There is a specific mention about blacklisting in the contract itself. Well, this is the circumstance under which the blacklisting can be done. If any case of fake, incorrect, inflated CV is found, it shall be dealt with very severely and would result in all possible penal action, including blacklisting, from these future projects of NHAI. This would also apply even when the consulting firm is not successful in getting the assignment. In case CV of a person is turned out to be fake, incorrect, inflated during the assignment, the consultancy firm will have to refund the salary and the perks drawn, including the interest of 12% per annum, in respect of any person apart from their other consequences. In addition to the above, 10% of the salary and
So
perks.
it is only in respect of a
fake CV.
fake, incorrect or inflated CV.
Exactly, Maharaj. There is no other provision, but since there is a specific provision engrafted in the contract for the purpose of blacklisting, Maharaj, they cannot adhere to any other aspect of blacklisting.
Yes.
And what you may kindly see that judgment of the Honorable Supreme Court of India, Maharaj, in the case of UMC technology. Now that takes care of all previous judgments.
Yes.
Lordship, can you come to page para 6, my lord? Lord, that case concerns, involves both the termination of the contract and blacklisting, as has been done in this case.
Sir, I do not have the privilege of paragraph 6, sir.
Why
I
it's
think
supported?
one page is missing, sir. Give it to me. It is after page 3, it is page 5. Give it to after page 3, it is page 5. You have?
No.
It is also not here. Page 4 is missing.
Can you see it is already?
Give it to me.
I'm so sorry. Extremely sorry. my lord.
Soft copy it is there.
It's there.
101, page 101 of the, by its aforesaid order date.
Well, my apologies, Lord, for not having the hard copy in order. By its aforesaid order dated 9th of January 2019, the corporation concluded that the shortcomings or negligence on the part of the appellant stood established beyond a reasonable doubt and proceeded to terminate its contract with the appellant and also blacklisted the appellant from participating in future tenders of the corporation for a period of 5 years. Further, the appellant's security deposit with the corporation was forfeited, and the appellant was directed to execute the unexpired portion of the contract at its own cost and risk. So, my lord, this judgment deals with both blacklisting and termination. Now, Lordship may kindly come to paragraph 13. At the outset, it must be noted that it is the first principle of civilized jurisprudence that a person against whom an action is sought to be taken or whose right or interest are being affected should be given a reasonable opportunity to defend himself. The basic principle of natural justice is that before adjudication starts, the authority concerned should give to the affected party a notice of the case against him so that he can defend himself. Such notice should be adequate and the grounds necessitating action and the penalty action proposed should be mentioned specifically and unambiguously. An order traveling beyond the bounds of notice is impermissible and without jurisdiction to that extent. This court, in the case of Nasir Ahmed, has held that it is essential for the notice to specify the particular grounds on the basis of which an action is proposed to be taken, so as to enable the noticing to answer the case against him. If the conditions are not satisfied, the person cannot be said to have been granted any reasonable opportunity of being heard. Next paragraph. Specifically, in the context of blacklisting of a person or an entity by state or state corporation, the requirement of a valid, particularized, and unambiguous show cause notice is particularly crucial due to the severe consequences of blacklisting and the stigmatization that accrues to the person or entity being blacklisted. Yet may be gainful to describe the concept of blacklisting and the graveness of the consequences occasioned by it. Blacklisting has the effect of denying a person or an entity the privileged opportunity of entering into a government contract. The privilege arises because it is the state who is the counterparty in the government contracts, and as such, every eligible person is to be afforded an equal opportunity to participate in such contract without arbitrariness and discrimination. Not only does blacklisting takes away this privilege, it also tarnishes the blacklisted person's reputation and brings the person's character into question. Blacklisting also has long-lasting civil consequences for the future business prospects of the blacklisted person. Then what to make, I'm skipping over the next para, what you can count para 616. The severity of the effects of blacklisting and the resultant need for strict observance of the principles of natural justice before passing an order of blacklisting were highlighted by this court in so and so case. The order of blacklisting has the effect of depriving a person of equality of opportunity in the matter of public contract. The person who is on the approved list is unable to enter into advantageous relations with the government because of the order of blacklisting. A person who has been dealing with the government in the matter of sale and purchase of materials has a legitimate interest or expectation. When the state acts to the prejudice of a person, it has to be supported by legality. The blacklisting order involves civil consequences. It casts a slur. It creates a barrier between the persons blacklisted and the government in the matter of transaction. The blacklists are instrument of coercion. Blacklisting has the effect of preventing a person from the privilege and advantage of entering into lawful relationship with the government for purposes of gains. The fact that the disability is created by the order of blacklisting indicates that the relevant authority is to have an objective satisfaction. Fundamentals of fair play require that the person concerned should be given an opportunity to represent his case before he is put to the blacklist. Similarly, this court in Raghunath Thakur case struck down an order of blacklisting of future contract on the ground of non-observance of the principle of natural justice. The relevant extract is, it is implied principle of rule of law that any order having civil consequences should be passed only after following the principle of natural justice. It has to be realized that blacklisting any person in respect of business ventures has civil consequences for the future business of the person concerned.
I have already read up to paragraph 24. You did not have to read.
Madam.
I understand there is another judgment of the Supreme Court which has been very expressive. I would say in a very lucid manner it has been done. That is the Gorkha Security Services.
Exactly, ma'am.
Which are on the same point.
Yes.
And the same principles have been.
Yes.
The fact parity can also be noticed therefrom.
Yes. And thereafter, the isolators and isolators.
Is there any subsequent judgment?
Yes. That is isolators and isolators.
Give me. Can you make a print out of it?
Paragraphs 21 and 23.
This judgment. Yes.
Paragraphs 21 and 23, madam. Paragraph 21.
Just one. Yes, I got it. Yes.
That's all.
Thank you. Yes, what do you say?
First and foremost, the only thing which is under challenge in this writ petition, may I go to the prayer matters? What they are challenging?
The order of debarment.
Matters, which has already lost its not very wrong.
So
Yes.
will it not? Because I have seen in many of the tenders,
Yes, ma'am.
they say that if you have already been debarred previously, maybe the tenure is over, you are precluded from participating. That's the perennial. And second thing is debarment creates an stigma, and it has a larger impact, or has a ramification in that regard.
Yes.
Throughout their commercial, the right to participate. So strict principles have to be applied in this case. We have also held in one of the judgments.
Certainly. To assist my notes, I have short date chart and written notes, my lords.
It's not necessary. Only thing is, are these clauses, are you disputing that this is the notice?
Yes, my lord.
On the basis thereof, the debarment order has been passed?
That's not disputed, my lords. One more thing, my lords.
That's the only thing I want.
Of the case, my lords. Regarding the jurisdiction and maintainability of this writ petition, my lord. That's why I'm just giving a brief background to the whole case, my lord. How it occurred. Lordships, on account of
Maybe he has 27 crores rupees, his wisdom, his decision must be there. He was absolutely reluctant. He was not really, I would say, very, very careful about it. And there was a loss suffered. There is no doubt about it. We are not entering into the gravity of the lapses, gravity of the misconduct, gravity of the misdeeds. We are simply concerned on a pure question of law. That if this is the notice, whether the order of debarment can sustain.
On account of this offense, my lord, there was two consequences, my lord. First, termination of the agreement, my lord.
No difficulty. Even if there are consequences for debarment, even if on the basis of this notice, can you impose the penalty of debarment?
Just giving a brief background, my lord. Just 2 minutes, my lord. I want to assist the honorable court. They challenged the debarment by the termination agreement, my lords, in an arbitration. That was challenged in an arbitration proceeding.
Can an arbitrator competent enough to decide whether the debarment is justified or not? Does it come within the purview of arbitration clause?
Yes, my lord. I will assist the honorable court. Ispat Nigam has already taken care of that, my lord.
What?
That even if in the arbitration proceeding, both the termination of the agreement and the blacklisting both can be dealt into by the arbitrator.
The only thing is, provided those are intertwined.
Exactly, ma'am.
Those are intertwined. It is not intertwined.
In this case, my lords, on account of the non-performance or the fraud made by them, my lords, two consequences followed, my lords. First, terminations, which were challenged in the arbitration, they lost in the arbitration also, my lord. Then they filed this writ petition with the Honorable High Court, challenging the debarment notice, my lords. My lordship may kindly see the few things, my lords. First, the agreement, my lords, where the agreement was executed, my lord. The agreement was executed in Delhi, my lord. At the principal place is executed in Delhi, my lord. Next, my lord, the cause of action. That's a debarment notice by Annexure 22, my lord. It has been issued at the principal office of Delhi, my lord. And next, my lords, the agreement contains a jurisdiction clause which says that the courts in Delhi will have that jurisdictions to decide the disputes, my lord. Lordship, may kindly see the debarment notice where it has been issued, my lord. Page 162, my lord. It has been issued from the head office, that's at Dwarka, my lord. Then page 48, that the date of the execution of the agreement, my lord, it has been executed in Delhi. The debarment notice has been issued in Delhi. The termination of the agreement was done in Delhi, my lord. But they chose to file it in the High Court, my lord.
Where is your counter?
And moreover, my lord.
Where is your counter?
Yes, my lord. I have raised this preliminary objection in the counter also, my lord. Serial page 189. First objection is with respect to the existence of an arbitration agreement, my lords. When the petition was filed, the arbitration was in process. They never chose to challenge this order before the arbitrator, my lord. Next, my lord, page 191. The para reads, it is further hereby submitted that though both the parties, the order of termination dated 75/2023 and debarment order 5th of June 2023 were already in place before filing the petitions before the Honorable Orissa High Court and High Court of Delhi. The petitioner chose to challenge the debarment before the Honorable High Court and the termination before the Delhi High Court.
No, no, no. What does it mean? It is further submitted that though both the orders dated, that is order of termination and the debarment, were already placed before filing the petition before the Honorable Odisha High Court and Delhi High Court means?
Since they chose to go for the interim relief, first they went to Delhi High Court, my lord. That's why I'm just giving the date chart, my lord.
No, no. Interim means?
For the interim relief, for stay against the termination of agreement, my lord, they went to Delhi High Court. Delhi High Court said that you raised all these points before the arbitrator. Then they came before the Odisha High Court also, my lord, against the department order. Then my lords, in the page 193, that's the integrity pact, my lord. So page 192, my lord.
Yes.
It is also hereby brought into the kind attention of Honorable Court the provision of Article 10 of the Integrity Pact, which was
Where from you reading at page 193?
Page 192, my lord. Serial page 1, internal page 5. Roman 2, my lord. Para Roman 2. Which was signed by both the parties. Article 10 specifically provides that the pact is subject to the Indian law and the place of performance and jurisdiction is registered office of the principal, that is New Delhi, my lord.
What is the work for which this contract was entered into?
The work was for, he was appointed as a authority engineer, my lord, for supervision
of the work where?
In Odisha, ma'am.
On Odisha. In
Yes,
relation to what is the nature of the work?
The nature was with respect to the supervision of the work executed by Government India, my lord. For
Correct.
rehabilitation of the national
Correct.
highways.
So this decision for release of those payments were made from where?
Lots of the inspection was done in Odisha. In their presence, my lord. There was a vigilance report which says that they did the violations, my lord.
The entire investigation was done in Odisha?
Yes, ma'am.
Yes.
But we had specifically agreed to be the place of jurisdiction in Delhi, my lord. And what the Swastik Enterprises say, my lord.
Now the question is, again I am talking about, the question is that this jurisdiction clause, when applies and when it does not apply.
When both the parties...
I am thinking in the perspective of Kosumingat judgment of the Supreme Court, which is there in my mind. And subsequently, there is Alchemist judgment is also there, which is there in my mind. So that is why I'm putting all these questions to you to ascertain.
Obviously, if any part of this contract is performed at Odisha, then they can also choose Odisha.
No. The difficulty is difficult. They are different. It is a different ball game. The law is not that.
Apart from the jurisdictional issues, my lord, then what my learned senior was submitting.
No, don't abandon.
I'm not abandoning.
You are surrendering. Don't go by that.
My lord.
You have something to say on that.
Yes,
that's why I'm asking.
What was executed in Odisha? The Joint Verification Committee and the Vigilance Committee did the inspection in Odisha. However, the decision was taken in Delhi, my lords, regarding the debarment and termination of the agreement. That's my humble submission, my lord.
The notice, just show cause notice was issued or served upon him where?
From Delhi, my lord.
From Delhi to where?
To their office in Delhi, my lord.
In Delhi?
Yes, my lord. Lordship, you can kindly come to that debarment notice, my lord. The address is quite clear, my lord.
No, I've seen Gurgaon.
Yes. Yes, ma'am.
And Chandigarh.
And Chandigarh.
Where is the jurisdiction clause?
Yes, ma'am. Page 219, my lord. Serial page 219 of my counter buttons. As a serial page 219. Internal page 32. Clause 10. Article 10. May I read, my lord? Clause 1.
Oh, this clause does not talk about in that sense. It does not exclude the jurisdiction of any other court. It should have been a jurisdictional clause that the courts at New Delhi shall only have the jurisdiction. What you say that the pact is subject to the Indian law.
Yes, ma'am.
Place of performance and jurisdiction is the registered office. So place of performance may be there, jurisdiction means the office of the principal is there, but the courts, how it is to be interpreted? I have come across for the first time this kind of a clause. I have some, in case of any dispute, the court or principal court within the New Delhi shall have the sole jurisdiction.
Regarding that, I would like to assist my lords with judgment swasti cases, man. Lords, you may kindly have a answer.
What? This very words are used.
Lords, this judgment says now.
I am quite conscious of the proposition of law on the jurisdiction point.
It should
The
not.
jurisdiction, this is two fundamental principles on this. A parties may choose to restrict the jurisdiction in a particular court at a particular place, no doubt. But there are two twin conditions which are involved in this. The first condition is that if the part of the cause of action arose within the jurisdiction of that court, and the other part or minuscule part arose in other jurisdiction, then the parties can restrict the jurisdiction to one court.
Right.
But the second principle is, if that court, there is not a single part of cause of action arose within the jurisdiction of the court, which the parties have chosen, then this clause has no meaning. Because the parties by consent cannot create a jurisdiction into the courts. That's the two fundamental golden principles.
Right.
I was just trying to figure out that how the part of the cause of action or the cause of action has to be understood. Mere issuance of the letter is a part of the cause of action. Service of the letter is a part of the cause of action. Or any act concerning the department and all follow-up actions which has been taken in relation to the department can be the only cause of action.
Admittedly, the work, the responsibility of supervising the work.
So it is all, everything is here.
Yes,
The entire misdeeds, or you say the lapses or the negligence, whatever the terminology you use was done here. Everything has been done here, and the inquiry also was made here. Now question is that the show cause was issued from there
Yes, ma'am.
to their office at another place, and the reply was given, the decision has been taken there.
Yes, ma'am.
Correct?
Yes, ma'am. The place of compulsory contract was also in Delhi, ma'am. The work was executed in Odisha. They supervised work in Odisha, but the place of performance contract was in Delhi, my lord, and was the Swastik Enterprises says, my lord, para 37, lord, if I kindly see. May I read, my lord? Para 37. The concluding para, my lord. In my opinion, the very existence of the exclusion of jurisdiction
Where?
clause in the agreement.
Where? Which?
Page 37, man. Para 37. Page 48 of Swastik Enterprises. Swastik Gas Private Limited. May I read, my lord?
No, you are talking about the words only, exclusively, all these words. No, I'm not on that. The question is that, does it relate to a jurisdiction of a court?
Additional.
That is Justice Loku. No, the main judgment also talks about in paragraph 32. the majority judgment.
This one.
Yes. Yeah, we have read it. Paragraph 32 of the,
32 and 37. So Lordship,
there cannot be any doubt about it.
yes,
There is no difficulty.
performance of the place of performance was in Delhi. The order was issued.
Not performance was here.
Performance was here, but contract was executed in Delhi. The notice was issued from Delhi. They have office in Delhi, which was communicated. They have also replied to the show cause notice from their office in Delhi, my lords. They chose to go to High Court of Delhi, my lord, for an interim relief against the termination of agreement, my lord. And the consequential order, which was the department order, they are coming to Odisha High Court, my lord. Simultaneously, they undertook 3 exercises, my lord. One is the matter before Delhi High Court. There was an arbitration proceeding, whole pledged arbitration proceeding, which they lost, my lord. And then the Odisha High Court matter, my lord. That's an humble submission, my lord. Coming to the point, my lords, whether blacklisting can be held in arbitration clause. It is not a dispute. The matter there is an arbitration clause, clause 8. That's not in dispute, my lord. So, lordship may I assist, my lord, with this judgment honorable court, my lord.
Section P application.
Yes, my lord.
Where in this process. You take before you submit your written statement, you take in that we know there is an arbitration clause, you participate with the legal.
So it's in the counter preliminary objection we raised, my lord.
Along with the written statement.
Along with the counter affidavit, I agree, my lords.
Can you, what is the language?
Lordship, as it was praised, my lord.
Language of section A of the arbitration of arbitration.
A judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him, so applies not later than the date of submitting his first statement. Lordships,
So
the background to this matter is that, my
I'm
lords,
saying you cannot do. And if you do not take it back, then you waive your right of arbitration.
when the matter was first listed with this court, my lords, it was traced by them that there's urgency in the matter. It was oral.
Procedure is provided, how you
My
can
lord.
do it.
My
You have to annex the copy and all, everything, you have to make out, please look at 8.3 or 8.2. Procedure is provided. What is required in this? Not really.
What's it? The applications referred to in subsection 1 shall be entertained unless it is accompanied by an original arbitration
All
agreement.
these things have to be followed.
We raise the preliminary
You
objection.
not
my
do
lord.
orally, no. It's not so easy, sir. You have to raise that fee first. One may not go for a arbitration. You can go to the court. And if the parties chose not to raise an objection and decided to have the dispute decided or adjudicated by the court, there is no bar that the judicial court or authority cannot do it. The arbitration is a private forum. It is chosen, the forum is chosen by the parties, and the parties can abandon that forum as well. So far as the jurisdiction point, let us consider.
Yes, ma'am. That's it. Next, coming to the merit of the case, what my learned senior was submitting my notes. The provision of blacklisting was never a part of the agreement, my notes. It's the clause 9, which my learned senior was referring, my note. That's a secluded clause, which is only applicable to the cases where fake CV has been submitted, my note.
There is any other clause?
Yes, ma'am.
Of blacklisting?
Actually, there is a policy circular by the authority.
Yes, ma'am. Any other clause of the agreement?
Yes, Lord. That's a policy circular, ma'am.
Does it by virtue of a reference or by virtue of necessary incorporation it is included in the contract?
Yes, ma'am. Yes, ma'am.
Where
Coming.
that the policy decision or the policy will be treated as an integral part of this contract.
Page 50, ma'am. Page 50. Is my lord at page 50? Definition clause 1.1, my lord. Applicable laws means the laws and any other instruments having the force of law in the government's country or in such other country as may be specified in the special conditions of contract as they may be issued and enforced from time to time.
What do you want to do? Sir, is the applicability of the law?
Yes, ma'am. They are.
So contract. The law and the contract are two different things. Law is enacted by the parliament or the state assembly by exercise of the legislative powers which is enshrined on the law. The contract are entered into right between the parties. Yes. What will be the integral part of the contract is provided by the party councils. And the law will be applicable to interpret the contract according to the contract act, which is enacted by the, that's the law.
Yes, ma'am.
In 1.1a. I'm asking you, there are many, like in the tender matters, there is a tender, it contains a clause that the general terms and conditions which are there shall be deemed to have been incorporated. And there are up to number of judgment which says that if those contains an artificial clause, then it will be deemed that the same is the integral part of the contract. Even if there is no reference. Because of the reference of incorporation, whose terms and conditions are followed in the contract.
Lordships, the policy circular at page 165, my lord.
I am asking you
Yes.
whether this policy circular becomes an integral part of this contract.
Yes,
I am again saying that show us that all circulars, all decisions that would be taken during the the currency of the contract that would be deemed to have been included in the contract itself. I can understand. Show us.
But the petitioner by his own acts has already admitted previous circulars, my lord, which was issued subsequent to the agreement, my lord. They chose to accept those circulars
If they
now.
have chosen, that does not mean that it is included in the contract.
That's it. Now let's presume, my lords, not accepting the facts, my lord. Let's presume the debarment clause was not in the contract, my lord. Let's presume. My lordships may kindly see the Patel engineering, what it says, my lord. What it says. Lordship.
SDP, you are citing 2005 judgment. What it says.
2012, my lord. Patel engineering.
Patel engineering.
Yes, ma'am.
SBP.
Lordship, may kindly see page para 22.
This is another judgment of Patel engineering.
In the same case, my lord, NHI was also para 22. Start with para 22, my lord. It goes up to para 25. The same case, my lord, NHOI was an opposite party, my lords. The same case, my lords, there was a debarment order. The same was challenged, not being in the agreement, my lord. What the learned court says, my lord, if para 22 gives a background, my lord, then para 24. The second respondent, being a statutory corporation, is equally subject to all constitutional limitations which bind the state in its dealings with the subjects. At the same time, the very authority to enter into contracts conferred under Section 3 of NHA Act by necessary implications confers the authority not to enter into a contract in appropriate cases, that is blacklist. The bid document can neither confer powers which are not conferred by law on the second respondent, nor it subtract the powers which are conferred by law.
Sir, again, I'm thinking about, that it strikes at the root of that judgment of UMC and the Golka security. Again, then the question would arise, even if the power to blacklist is there, whether the procedure which you adopted can be justified.
Yes, ma'am. Yes, sir. But coming to that, Mala. But annexure, the case of the petitioner was that.
The law, UMC judgment and Golka. Please.
I agree, ma'am.
Tell us, because you have seen, that's why I asked you, are you sure that this is the only show cause notice? From the show cause notice, show us that you have articulated an intention to blacklist him. Any language which you can find on the letter, show cause.
Page 127, Madam.
Please read the show cause notice that you contemplated and in proceeding to blacklist him. You have said that you have done this, blah. And then what you want to propose?
In view of above, it is requested to submit your explanations within 7 days from the issuance of this letter as to why disciplinary actions shall not be taken against the authority.
Disciplinary action. What does it mean?
Disciplinary action includes the termination of the blacklisting allowance.
Does it not include only the termination?
That had been the case that might have been specified in this case.
That is what the UMC says, that you have to very clearly say that I am issuing this show cause notice to debar you for blacklisting. Have you read the UMC?
Yes. But there is to be specific mention about the intention to debar.
The word should be there that you want to blacklist.
These are my submissions, my lords. First regarding the jurisdictions, second is regarding the arbitration, my lord, third regarding.
In reply on jurisdiction.
Yes. With regard to my approach to Delhi. That
Another case, there are any other points we can't-
that alchemist.
Tell me about jurisdiction.
The alchemist judgment is the judgment which clinches the issue. But in fact, since I also remember that case, it was regarding Malad, it was a demerger of a State Bank of Sikkim. The notice was from the Malad Sikkim. Then Punjab party bidded for that. Then bid was cancelled. Then the Punjab High Court held in favor of Malad, held against, went to Supreme Court. Only two paras are in Malad. From para 27. AIR 2002 Supreme Court, a question of territorial jurisdiction came up for consideration. Filed a petition under Article 226 of the Constitution in the High Court of Gujarat, claiming benefit of the passport scheme under the Exim policy. Passport was issued by Chennai office. Entries in the passport are made by authorities in Chennai. None of the respondents was stationed within the state of Gujarat. It was therefore contended that Gujarat High Court had no territorial jurisdiction to entertain the petition. The contention, however, was negatived and the petition was allowed. The respondent approached the Supreme Court. The judgment of the High Court was sought to be supported inter alia on the grounds: 1. A was carrying on business in Ahmedabad. 2. Orders are placed from and executed at Ahmedabad. 3. Documents were sent and payment was made at Ahmedabad. 4. Credit of duty was claimed for export handled from Ahmedabad. A denial of benefit adversely affected the petitioner in Ahmedabad. He has furnished bank guarantee and executed the bond at Ahmedabad, etc. Allowing the appeal and setting aside the order of the High Court, the Supreme Court held that none of the facts pleaded by A constituted a cause of action. Facts which have no bearing with which fell from my law. Facts which have no bearing with the list or dispute involved in the case do not give rise to a cause of action so far as to confer territorial jurisdiction on the court concerned. And same thing was followed ultimately in this case. And then the Punjab Haryana High Court was held not to have jurisdiction. It was not Sikkim. And another aspect, what you may kindly see, Article 226(2) of the Constitution.
Cause of action.
Yes.
That is why I asked those questions.
Yes.
Yes.
Lordship was raising regarding that inspection report, my lords. The inspection report jointly signed at Delhi only, page 136. In Odisha, but it was jointly signed in Delhi.
But I'm appearing on behalf of Dr. Mishra. But I am representing the opposite party number 5. Please measures. Challenge the order under Annex 1, which has been passed by the open number 4 minor, without giving opportunity of hearing to the present petition. And hence, natural justice in violated minor. And meeting minor signed attention to page 15 Annex 1. Subject application, the related to file rise, ZVK IM 98 from 9 control order. Whereas Indian Joab, which one of the reference? Page 15 Annex 1, man. The impugned order. Lordship. Second, whereas being agreed by the order of the DDN Jora. Yes. What happened there? My lord, this order has been passed and I am before my lord. No, this was passed way back on 3rd of March. Yes, my lord. So he has kept the matter pending for factual report. Yes, my lord. Was it filed? My information.
Here, what has happened, my lord? Challenging the order of Deputy Director Mines.
But you did not have to repeat.
My-
I'm simply asking the last portion of the order.
Last portion,
That
in fact-
factual report to be submitted within 15 days. Was it submitted within 15 days? I'm just asking.
no, my date was fixed for verification in presence of both the lessee as well as the crusher unit, so far as the petitioner is concerned. On several dates, they didn't appear.
Where is a provision for an appeal, and where is the document of appeal? Appeal petition dated 2/2/2023.
I have, no, I have not been sought with.
Please see, I have understood what you wanted to say. Is there any copy? Do you have the copy of 2/2/2023?
Referred by my.
Where is the?
I don't have the copy.
Is?
I don't have the copy of the appeal memo. But here, in fact, after passing of this order, an inquiry was
I
made.
will come. I will ask you many questions. You don't have a copy.
No,
Then you can't answer whether they were made a party there or not. That's very important. Whether you were a party or not. Under what provision the appeal comes?
This was filed under Rule 17. The Rule 17 of the Odisha Minerals Prevention of Theft, Smuggling and Illegal Mining Regulation of Possession, Storage, Trading, Transportation Rules 2007.
You are representing. You are medium Joda.
Opposite Patmore 2, 3 and 7.
No.
I am the applicant for the operator.
Are you an appellant?
Yes,
Appellant means OMC Limited.
yes.
You have filed an appeal. Don't you have the copy of the appeal to be? And there is a mandate that within 2 months it has to be disposed of. This is the order is of 3rd of March 2023. Still not there.
In fact, after this order, my lord may kindly say.
After this order, we are concerned with this order. We are concerned with what happened before this order.
After this order, we are not concerned. Before this order, what happened? Have you made them a party? If you have made them a party, whether any notice was given to them to appear? Because the order dated 3rd March does not reveal that there was any representation on their behalf. It is only the authority who passed the order and you. And secondly, he has not recorded any reason, recorded the submission of both the parties, and then seriously jumped to the conclusion that you keep your order in abeyance. Means you pass the stay order. Will you not record? I mean, will they not record? You are representing. How can this order be sustained? We have seen many times, we have said that you have to record the reason.
Record the reasons. It cannot sustain. No,
Nothing has been done.
no reason. To that extent, I would barely.
An appeal petition is disposed of factual report.
And factual report, it was kept pending.
I do not know. How can you do it?
It should not happen. Let the parties be
My lord's permission,
relegated back to the appellate authority.
Go back.
but one more, I have filed an additional affidavit. Last occasion, my lord can taken time to take permission or consult with their client. In the meantime, their time limit has expired, my lord. OMC is no more. Because when the order was passed, at that time OMC was not competent to file the appeal, my lord. Because I have
Go
filed
there and take a preliminary objection before the appellate authority that the OMC is not competent to file an appeal. No locus standi. Go there.
my lord, within limited period. Your lordship.
Go there.
My lord.
Brother, this kind of. By an order dated
Item number 7.
Maybe pardon, item number 7, I'm appearing on BC. Lordships, we have challenged the order under annexure, the letter under annexure 17, wherein the executive engineer has communicated that the proposal of rescission of my contract
What
has
is
been
the
approved.
of annexure 17?
Lordship,
Let's if I make a small
Yes.
request.
139.
139, page number 139.
Oh, nothing has been decided. They have simply asked you to remain present for the purpose of final measurement of the work which you have undertaken.
Yes, Your Lordship. That is, in fact, subsequently, if Your Lordship sees annexure 18 and 19, they have allotted me further work. I have been allowed to work even after the communication of such rescission.
Why you are so much afraid of not undertaking or participating in the exercise of measurement?
Lordship, there is subsequent development which I would like to bring to Your Lordship's notice by filing a memo. The petitioner has in fact submitted a revised work program wherein the petitioner has vouched that the superstructures, all the 3 superstructures will be complete.
The authority that you are
Yes,
you are asking me to appear for this purposes. Please go to the authority, apprise them that I am also doing an extra work. If final measurement is to be taken for the purpose of release of the amount, then that may be deferred. If I complete the extra work also, that should be taken care of. Go there. Why we will interfere in this?
if Your Lordship kindly sees that the revised work program has also been recommended to be approved by the chief engineer, and the same recommendation has been also forwarded by the superintendent engineer. If Your Lordship,
No, madam.
I'm just
Go there.
praying if any instruction could be obtained as to the approval of the revised work program.
That we can't be used as a tool for gathering an evidence for you.
Then Your Lordship may kindly, I'll obtain certain instruction if such
Nothing
a.
instruction. You have received the actual instruction.
Today we have received, in fact, that
Then
the revised work
appropriate it.
program.
We are disposing of. Appropriate the instruction and then we are disposing of.
Lordship may kindly reflect that any action taken will
What's
be.
taken? Yes. Have you made the measurement or you have deferred? These are the 2 years old case. For this fringe issues, these are pending here.
Counter has not been filed in this.
What counter you will file?
The only instructions which I received is the work is 15% of the work has been complete and that's it. That is the only.
So you go there and make the extra work, whatever, everything you go there. Have you made the measurement or not? You have done.
That knowledge I have not. done.
Any interim order was passed?
That's only
No. There was no interim order.
interim order.
Petitioner is under the threat that his contract may be will be rescinded.
Oh, this is what is approved by the recession.
Yes. Annexure 24 series also they have called me for.
I just read the second portion of the order, second paragraph of the order. Yes. If you want to rescind the contract, then you'll have to give them.
But this instructions which letters which the petitioner submitted shows that revised work program is already submitted.
So this recession has to go.
That I have that's because I
Take a instruction. If it has gone.
then nothing said.
Next Wednesday.
Yes. Item number
Okay.
8.
Remember, we followed that it will be trying to write the standard application. And the consummate next week.
Why? Sir, when you were served with the counter,
Yes, I have served with the counter.
when?
Malad long, but.
Long, then what you were doing? Why you did not prepare your rejoinder?
Malad, he is suffering from cancer and now at Bombay, twice he has been. But it will take 2 days time. Next week, edition.
Rejoinder in course of this week, next week.
Malad.
Service must be ensured in this week.
Malad.
Both the matters.
Both the.
Item 9.
But item 9, where the exemption exempting the ET qualification. Or the
Now the judgment has come.
Yes, my lord.
Justice Datto's judgment has come.
That is annexure key, my lord. That I have filed and copy.
On that basis, yes.
That is available.
Justice Datto has recently said that the NCRT has closing off in the light of this.
My lord, your lordship kindly have glanced to your lordship in occasion of one of the cases where the reverse trial was made. Your lordship was going to dismiss, and after going through this Anjuman judgment, and on the request of the government, my lord, your lordship formulated the point also. Your lordship kindly.
So formulated the point, we are deciding it here. Other what formulated the point?
Yes, we have.
Why you are referring it to it?
Well, I am referring to reason being, since this batch of cases, the exemption.
First, let it be decided, then everybody will follow with the same. Next. Let this matter be decided on the basis of this judgment. What remained? Can we argue anything beyond that?
No, madam.
Then
But
what remained?
my humble submission is the provisions as available under elementary cadre rule exempting the qualification that should be declared ultra virus. That is my prayer aim. And B is be given promotion to the all qualified person having TT qualification. We are all pensioners having TT qualification. In the first case, your lordship. And I have prayed for my prayer may kindly before my lord let me complete last one and this your lordship kindly turn to prayer matter. What is my specific prayer?
The view is pending before the Honorable Supreme Court. That order which is relying upon that has been reviewed by.
No, this is another matter.
Yes, it was not.
Suggestion, subject to your lordship's acceptance.
No, we didn't know. He has gone much ahead. We just thought that the order has been passed by the government denying them certain rights because they do not have the TET qualifications. So we thought that after this judgment, it is imperative. So giving them a time to qualify this, there is no difficulty. We were thinking, but now he says that the provision has to be declared ultra virus.
Yes. We are all qualified teachers. Our promotion has been blocked, my lord, by the underqualified teachers.
They have been promoted.
And they have been promoted. That's why we have challenged the virus of this 15-2D malady.
So now, suppose the virus is declared, will it take a retrospective effect?
That is the constitutional bench judgment.
It will take a respective. All action which has been taken at that point of time will go.
My humble submission.
I have to learn. You show me that you say constitution bench. I have to understand because I am ignorant. I must be very candid. I am ignorant.
It is available.
I am ignorant of this proposition of law. So that's why I am asking.
I have, my lord's predecessor, all the judgments were placed. In the last judgment, your lordship kindly have learned.
Please.
That point I also taken care of.
Yes. Because there is another facets of the legal, I would say, the field. So that is whether those principles of the doctrine can apply.
What I say, here, certainly, so far the TT qualification is concerned.
It is imperative now, as of this day, after this judgment says it is imperative.
Yes.
It is mandatory. I'm sorry, I use wrong words. I will use those words which you all of you use.
All of us.
Yes. So
Because that has been invoked by invoking
so it is mandatory now. There who has not done it, a timeline has been given within which they have to complete it. Please consider. Even if they have been given a promotion, if the Supreme Court has given them a fresh lease of life for a limited period, if they qualify the TET examination, then will you say that their promotion was bad at that relevant point of time?
I am just coming to the point. That is the crux. That is the crux, is required to me. I am coming to. Your Lordship kindly
So
appreciate.
the credit must go to me.
I understand, Your Lordship formulated the point, man. Here,
Because
in the Anjuman case,
you were going way more.
no, my lord, I am not going to that.
You should be thankful to me.
My humble submission, if Your Lordship kindly
Seeing
appreciate.
his energy levels.
Your Lordship, because it is giving much more pain, my lord. We have concluded hearing, it could not be, the judgment could not be delivered. In from 2023, my lord, still it is not being ended. And the unqualified persons, they are getting promotion one by one. And Your Lordship kindly appreciate.
Saying to this page, if you had I think the first or the second officer, consider.
That's
bringing all those facts.
why I am drawing my
Argue. Tell me what to do.
In the Anjuman case, those who have got promotions, they have to qualify and they will retain the post. That was not the issue, man. Your Lordship will kindly appreciate. Various the SLPs was clubbed together, even against the judgment of the Madras High Court, where the rules were declared for ultra-virus. That against that judgment, SLP was filed. But my humble submission here, everything has been discussed elaborately. Nothing more I have to say in paragraph. But my humble submission, there they say, for promotion, certainly TT is mandatory. Nobody is to be has any right to consider for promotion without TT. Therefore, they say even teachers, those who have only 5 years of service or less service, they may continue without promotion till their retirement. But those who have more than 5 years of service, by invoking Article 142, they will continue if they will acquire the TET qualification by 2 years. Otherwise, they will be given compulsory retirement with all terminal benefit if permissible under the rules manner. My humble submission before Lordship is, here what has happened? The provision which we have challenged that came in the year 2019. Promotions on the basis of that exemption were made in 2001, 2021, 22, 23. Your Lordship kindly appreciate, if at all this, while we are available and they have been given promotion, unless and until this provision is declared ultra-virus, then certainly they will march over and they have blocked our promotions. In their promotion post, they have offered matter.
I'm again asking a question. Let us hypothetically, don't take it as my observation or become more energized or enticed with that. It's only for the purpose of understanding I am putting a question. Let us proceed on a hypothetical basis that whatever you are saying is correct. Let us proceed that we declare the particular provision of the statute to be ultra-virus. Then the larger question, any action which has been taken prior to the declaration of the provision to be ultra-virus, what would happen to those actions? Can they go in air? Can they be buried 2 meters beneath the ground? What? we are concerned with this situation now.
Well,
You are saying everything. Now let us see that we proceed on that basis. What relief can be granted to you? Tell. What would happen to those?
My humble submission before Lordship, even in 2003, where the matter was for the first time issued notice, in case, my lord, that order is there, any promotion subject to result. If your lordship, my lord, in the event, the provision.
Sir, this provision, according to you, came in existence in 2019. The promotions have been done in 2019, 20, 21, 22. I am saying that when there was the provision enacted by the legislators using their legislative power, if the authorities or any action is taken thereupon, what would happen to that action?
Let me.
Today, we declare this provision to be ultra.
Yes, Malad, that is Malad. But I am just coming to Malad. I understood the proposition, Malad.
Don't go 2003, 2005 model.
Malad.
Forget about it.
Malad, my humble first.
When exemption clause is brought to the statute book in 2019 and the action taken thereafter. Sure.
Malad, I am just coming to. That is the crux, Malad. That I have, Malad, I know that is the issue is required to be answered, Malad. Here, your lordship will find the exemption provision which came by way of amendment that is not under the subordinate legislation, Malad. That is by invoking proviso to Article 309. But by that time, the 17th Amendment of RCFC Act has already came into force, being incorporated to the RCFC Act, RT Act, in the year 2017 by giving effect to, with effect from 2015. It had 4 years grace period. Earlier, under the statute, under Section 23, 5 years was the relaxation period. 4 years by way of amendment in 2017 came into force, which period is to be ended by 31st March 2019. This Gazette notification, in exercise of power of 309 proviso, came into force because in Odisha, the elementary cadre rules which was governing previously prior to commencement of this RCFC Act, but that gone amendment in 3 stages in 2009, 2014, 2019. We are concerned with 19, confining to our issue with exempting the qualification which was prescribed under RT Act, read with the NCT notification, as it has been declared in non-given case. My humble submission before Lordship is, had it been in legislation, your Lordship, my Lord, I bow down, then yes, certainly that question would have arisen. Here is the provision which we have asserted solely on the ground that it is hit by the doctrine of occupied field. That means the governor power to issue the amendment or bring such provision is completely ousted after commencement or occupied by the Legislatures Act.
Probably
that matter, I am citing that judgment.
Understand what I wanted from you. Either you are consciously avoiding the answer. I am again saying either the doctrine of occupied field or a doctrine of excessive legislation, a doctrine of legislations by taking a different route in bringing an amendment into a subordinate legislation, assent whereof is given by the governor or by the president, and this cannot be done by through a governor. All these things I agree what they should be. Now the question is that they have been promoted on the basis of this particular legislation. What would be the fate of those promotions? I am just putting a questions to you. What will be the fate of those promotions?
But my humble submission,
even if we declare this provision to be ultra vires.
Then your Lordship, that I have.
Sure. He wanted a law in this subject. Forget about it. What will happen? We know if Supreme Court has also held that you can't bring a subordinate legislation which either runs counter to the substantive act or is repugnant to the substantive act, inconsistent with the substantive act. I understand those principles you did not.
Here it is not the subordinate legislation, madam. Had it been done in exercise of power under section 38, then you could have got the footing of the yes,
Whatever then.
here under the 309 provides,
What is then? What is this problem?
madam.
Is it not a subordinate legislation? Then it is what?
Madam,
Cannot be regarded as a delegated legislation. Then what is the character of this?
madam, I am just, may I read, madam, the
309 says the governor can issue any legislation or regulations being a character of a law, just to fill up the gap or there is any penalty.
such a power is not available with the governor when it has already been enacted. But you lordship, that is the judgment, madam. That I am coming to, madam. May I read, madam? One by one.
Probably again I am saying that is my, I would have misfortune, my incompetence that I am
No, madam.
unable
At least
to convince you.
Madam, your lordship, allow me only 5 minutes, madam. Your lordship only allow me 5 minutes. What is the case exactly? That let me place.
We understood the case. What do you think? We have not understood. We understood the case. The question will be of the ultimate relief to be gotten. We will declare provision as ultra. Happy?
Then consequences to follow. Consequences to follow. Then in case a provision is declared ultra virus, what would be the consequence that has been laid down by the Honorable Appeals Court?
You will be happy with that? No further consequential order will be passed?
Madam,
if you are happy, we have no issues.
Madam, only the second prayer is a promotion for direction. We have not said nothing, madam.
No.
Beyond that, we have not said
No.
nothing. Your lordship kindly appreciate. My prayer, your lordship will find.
No.
My first prayer is to declare ultra virus.
So,
Second prayer
that
is
is why-
to consider all qualified hands.
Now you are coming in.
Madam, let them be considered.
Let me say.
You
have come in my clutches now.
Madam.
Correctly. Your second.
Yes.
You wanted a promotion?
Yes.
To what? Imaginary post or what? There must be a vacancy. How the vacancy will come? By demoting those promotees who do not have the qualification to come to a bidder post. Then the vacancy would come. There you will be adjusted. Can we do it?
But if it will not be done, my lord, then that will go against the principles
That
of law.
is what I am asking you, sir.
That is why I am saying, madam.
Please tell me what to do.
Madam.
Where to do.
Yes, madam.
Now you understood.
Madam.
Please.
Madam. Your lordship kindly appreciate. But the judgment bundle that I have given, that at page, that is 232, 223, madam.
Actually counted.
In every state,
This
at
issue.
the relevant point of time, there was no occasion for this PET as a condition for this. Now, NCRT or what is this? NCTE subsequently enacted a guideline or enacted a rule or mandate that every teacher must qualify the PET. Now the question, a lot of questions that arose everywhere in every state. Yes. First question arose whether these guidelines or the instructions has any statutory tracking or mandate which has been given is to be followed. Then the Supreme Court in one of the judgment came, no, this is mandatory. And you have to follow, you can't defy, because in one of the judgments, Supreme Court considered the genesis of the creature of this NCTE, how it has come, all these things were considered and then say it's a mandatory. Then the RTE Act came. Now the difficulty is that once they give a mandate, certain states were not following because the candidates were not having those qualifications. And there would remain a vacancy for a longer time. That was the whole difficulty with many of the state players. So they recruited those by amending something. Then it was challenged again. Then it says that you can't do it. Then large number of people who are already there, because if they are removed, the difficulty is ultimate sufferance would be caused
To the beneficial students.
children. That's why the Supreme Court in that case, if it is 5 years or less period which is left, don't insist. Let him continue and honorably go out.
Without promotion. Yes.
More concerned with the promotion. I understood, sir. Let him continue and then go out. The second says that whoever has not got, then in that event, 2 years period is given. You must qualify.
Yes.
If you do not qualify this test, then the consequence is also provided what to do. Now the situation has come. Once the Supreme Court has given 2 years buffer to qualify, then it does not indicate at what course. Whoever the teacher having no TET qualification shall remain stagnant there, as I perceive the judge.
Yes.
Would remain stagnant there for 2 years. Let them qualify. If they qualify, there is no difficulty.
Further service progression would be dependent on acquisition of.
Oh, that is there.
Well, anybody got promotions prior to 2019 without qualification, for them it may be applied. But after 2009 exemption provision, by taking advantage of exemption provision, they got it. Well, that's a question is required to be decided. But a large number of persons have got promotion prior to that cut-off date, as fixed under the RTI.
That could also be covered.
They may continue. But for them, we have.
Supreme Court has not said anything. The Supreme Court has also taken into consideration the subsequent
That will be covered by the
position everywhere it is there as on the date of the judgment. The Supreme Court has taken into account. It did not make any distinction between an appointment, prior appointment, after. Otherwise, the Supreme Court would have declared those appointments to be absolutely invalid, illegal, and should have thrown them out.
No, but
the position is that the 2 years have not passed. I think this judgment is relevant in
hardly few months.
2020.
But it is a rider. Your Lordship kindly appreciate. Law is they cannot be considered for promotion. They cannot be given promotion. That doesn't mean without qualification one has got promotion. They will continue.
Now they have an opportunity to go for 2027.
Up to 2027 is the balance.
Well, my humble submission is
This one,
the
the
first
whole-
principle what held by the Supreme Court, basing upon that RCFC Act, read with the NCT notification, that is, no promotion can be imagined without TT qualification. They have no right to be considered for promotion without TT. If at all, they will be allowed to continue those who have got promotion after 2019, basing upon this provision, then ultimately what will happen, my lord? It will indirectly frustrate the first mandate, my lord. The first principle will be frustrated there. My humble submission before Lordship. Because had it been a case, we are not at that time in Lord Mallards more than 70,000 teachers having the qualification. But they got the promotions by marching over the qualified hands. That is the crux, my lord. That's why they have come forward to challenge this, questioning the validity of this provision, exemption provision. Otherwise, my lord, we will get no justice, my lord. If we are my lord, our fate has been sealed, my lord.
Sir, paragraph 214,
My lord.
read 15, read what more, it is not Article 142. Article 142 is paragraph 216.
My lord.
14 and 15 is not Article 142. It is Article 141.
It is Article 141.
It is only paragraph 216, which is Article 142.
My lord. Invoke the article and extended the, my lord, the relaxation period.
Sir, the court was conscious that we will not terminate the service.
True, my lord. I bowed down, my lord. I don't, my lord, say so, my lord. Your lordship, ultimately what will happen? The first principle which was offered, my lord, that will be frustrated indirectly.
No, sir. that-
And we will be debarred, my lord.
You are not debarred, sir. You do not want. I can't, now I have lost the knack of arguing as a lawyer after such a.
My lord, your lordship kindly appreciate. Well, one thing your lordship visualize on the pretext of the Orissa elementary education, my lord, cadre rule, my lord. My lord, cadre rule in reverse, five cadres earlier, it was made 6 under this amendment. But in the 6th cadre, from the bottom stage 2, they have already crossed not 1, 2, 3, 4. They have occupied almost all the promotional posts. But particularly when we are in thousands, more than in number, we are available in the cadre. You are kindly appreciate. And basing upon the hard the anybody got promotions prior to that law, my lord, then certainly for them, my lord, they may be protected. We are not saying so.
Prior to this judgment, it was nothing, because once you have entered into a cadre, and if the cadre is not differentiated on the score of TET qualified teacher and non-TET qualified teachers, it is a one single cadre. Then whoever there in a higher position of the cadre is entitled to a promotion or not promotion, to be considered for promotion. That is the vested right. The right to be considered for promotion is a constitutional and vested right.
But this is fundamental right.
Right to promotion is not.
No, yes, man. It is not the fundamental right.
Definitely not.
Man, here what has happened? Chances of consideration of promotion has been taken out.
Sir, now you are emboldened because of the judgment of the Supreme Court.
No, you are not excluding the judgment, we have argued this case and concluded, man.
Supreme Court in paragraph 215 and 60 did not make a differentiation on a promotion by basis or on non-promotion basis. It says that in-service teacher.
In-service.
Means though the teachers who are in service now, having no TET qualification, says that if we remove them or if we dismiss their service, it will be too hard for them on that. Then he says, I am exercising my Article 140 and giving them 2 years time to complete. What? So not to be disturbed in service till
completion of
31st August 2027.
Well, my humble submission before Lordship is here is a case for something different.
No.
But your lordship, you may kindly look to this matter. Well, what judgment I have opened, your lordship. It was my lord. It was before the Honorable Supreme Court. Reference was whether a provision being declared ultra virus, what will be the consequence? You know, they have in paragraph 95.
Will not found or occupy a place in the statute. Nothing. It is totally effaced or taken away from the statute.
From the date of inception, it will go. The provision from the date of once it is declared ultra virus, from the date of inception, it will go. Then automatically the consequence will go.
Are you aware of a doctrine of factor? Yes, not overall. Doctrine of factor or a de facto doctrine. Are you aware? Supreme Court has embraced it.
Well, here,
Supreme Court, that's why I say that I have not opened my mouth for two doctrines. I asked you a simple question. I can give you a judgment.
Perhaps you will not see whether I am clear or not.
I am giving you a judgment. Please read the judgment on a de facto doctrine and come. The Supreme Court has embraced. I can give you a multiple. I can give you 1991, volume 1, SSC, page 319. 1987, supplementary SSC 401. And 1981, volume 3, SSC, page 132. Please look these judgments and then come.
1991 SSC in 1987 SSC 401.
Please read. This doctrine has been embraced in the Indian judicial system. And three judgments which I gave, the Supreme Court has said, what would happen to such position?
That controversy, I think here it has been resolved by 5 benches. Constitutional bench judgment.
Please read it.
May I read, Malad? May I read, sir?
It goes from the date of inception. You are absolutely correct. That's why I'm saying now, these are the situations. These are the principles which has been decided that if an appointment has been done on the strength of a provision which was subsequently found to be wrong or illegal, then this appointment may go. But the action which has already been done, that would be saved by this doctrine. What is the action? The action of promoting the persons. That would be saved by this doctrine. It will not be rendered null and void. It will not be rendered illegal. Please go and read it.
It is from third Malad.
That is what I'm saying. You are proposing a principle from the date of its inception, but I am giving you further. When I asked you this question, keeping in mind those judgments. Please go.
Let it come Malad 3rd December. I will certainly I will try to make Malad. If it is not Malad, then something. My humble submission is here. I am not saying they should be ousted. They have got the promotion, but the first principle declared promotion is not possible at all. If at all,
so there are two situations.
Then indirectly got approval.
The situation is either they have to revert it back to the feeder post.
Yes, they will not be ousted. In that event, they will not be ousted. They will come back to, and from the date of acquisition of TC, they will be considered.
Is it permissible?
That is my humble submission. From the date of TC, they will be considered.
I am breaking my head to a solid rock I'm unable to. Now I have been able to pierce. This is what I'm saying. Will it be permissible to bring them back?
Let it come, my lord, the third
They
December.
have taken, they have enjoyed the scale of pay attached to the promotional course for a pretty long time.
My lord, the whole difficulty is the post has been occupied by them. Then what will be the relief for these qualified hands? Those who have been marched over in by virtue of an illegal provisions.
And some, no, correct. It is some of the because all the they will start withdrawal.
They will not be in that event, my lord, they will not be thrown out. That is not my logic, my lord. I am not advancing that. They will be covered by that. But in the indirectly, the first principle will be frustrated.
And the niceties has to be thrown out. You wanted somebody who was living in a castle to come back in and live in a castle.
It is not that the qualified hands will be overridden by them. Unqualified for them. Let it come. Start December.
Protected their interest.
Malad.
Protected their interest. Can't be. They can't be reverted back. You just read the.
Malad.
Read good. Unnecessarily, that way I say I have lost all my acumen as a lawyer by passage of time. Exhausted, needing his energy.
Here the case situation is different. That's why, madam, I am pursuing that point. On the strength of that constitutional bench, which says, madam, all the fruits will also go. In the event of ultravirus, declared ultravirus, everything will go. Madam. I will.
Next week.
Next book.
Item number 10.
May I please your worship about this? The state admits that while floating a tender, this will not exhaust your lordship. Your lordship will find it very relaxing. The state floated a tender. While floating the tender, they have committed an error in entering the plot number of the source. Now the source was put to auction. The auction purchaser deposited the money. Everything has been done. The work order was liable to be issued. At this point in time, it was detected that the plot number for this is erroneous. And they have gone on to cancel the tender. This has been assailed. In fact, they admit it is their error. And the question that was posed, in fact, when the matter was heard by a coordinate bench, the question that was posed was, is it possible on the part to correct such an error? Now, the rules under which the auction has been conducted, that rule itself provides for a correction of the errors. If you're, I'll now take your lordship shortly to the facts of the case. Is two sources for quarrying stone were identified in 2016. They were put to auction. That is Tadoba 1, Tadowada 1 and Tadowada 2. These two sources were put to auction in 2016. The sources were settled. They were assigned plot number 78. They were put to auction. They were settled in favor of auction purchaser. As far as this petitioner is concerned, he succeeded in respect of Tadowala 1. Tadowala 2 went to some other person. They operated the source for 5 years after getting all the necessary clearances from all the relevant authorities. After lapse of 5 years, the source was again put to auction by assigning the same number. Now I have succeeded as far as the second source is concerned, the Tadowala source 2. And I was called upon to make the deposit in question. I made the deposit in question. Environmental clearance was sought for. Thereafter, my lords, they adopted new technology of satellite imaging. In the satellite imaging, they discovered that the source is not on plot number 78. It is on plot number 62. 61 and 32. And on the basis of this discovery by the state, they have gone on to cancel the tender.
That is what is being assailed before your lordships. And my lords, if your lordship sees, I will just show to your lordship the counter affidavit filed by them. Counter affidavit dated 22/4/2025. Your lordship, sale of the Sairat source, Tadobala stone queries 1 and 2, which has been published in the newspaper on so and so and auctioned on so and
So
so.
this order was challenged in the earlier writ petition.
And the court asked the collector to reconsider. So annexure 9 was filed.
The reconsideration has not been made.
Reconsideration?
There is a discrepancy in the land schedule and therefore consideration does not arise.
Yes, ma'am.
What is the ground? They have to consider on merit.
They say that since the land schedule was wrong,
No, they have not cancelled. They have not shown that they have cancelled. The earlier order goes.
No, they have not given the grounds. They just
the earlier order that was cancelled. That
Cancelled.
was challenged in that particular writ.
Yes.
Section 7879.
And that again gets confirmed in annexure 12 and page 88. They reconfirm that. In view of the above fact, on annexure 11,
Where is the order of the High Court in that which?
that matter, quoted matter, quoted. I just showed you.
Was this order set aside or was it?
Page 13, my lords. Page 13 of my writ petition.
Yes.
Paragraph 4. As it appears, the petitioner made a grievance before the opposite party number 2 to consider him to continue as successful bidder for operation of Tadobala Stone Quarry 2 under Rajigarh Tehsil by correcting the plot number from the district survey report on minor minerals and to revoke the cancellation order dated 22/3/23. On the basis of such grievance, opposite party number 2 by letter dated 25/8/23 under annexure 10 intimated opposite party number 3 to inquire into the grievance petition of the petitioner, pursuant to which he submitted a report before the opposite party number 2 wide annexure 11 dated 2/9/23, which is pending for consideration.
Annexure 11 is the report.
Annexure 11 of that writ petition. Of the previous.
That appears to be a report.
Yes.
Report submitted before
the collector. Before by the Tehsildar before the ADM. Before the ADM. And the ADM's order.
85, page 85.
Page 85, yes, yes, ma'am.
What is the recommendation dated 2/9/2023? Where is that 2/9/2023?
That is annexure 11 at page 85.
Oh, this is what?
Yes.
But there was no recommendation to change it.
There was no recommendation.
No.
So, Manoj, this, in my humble submission, was an error which was liable to be corrected at their end. And it was permissible to do so under the rules under which the auction has been carried out. The
auction rules?
Yes, Manoj. That is Odisha Minor Mineral Concession Rules 2016. This auction has
also an auction rules.
Yes. No, that is with regard to major minerals auction rules is there. And here the auction is conducted under Rule 27, Grant of Quarry Lease. That is Chapter 4.
Yes.
The relevant section on which I invite your Lordship's attention for correction, that is Rule 55. Power to rectify apparent mistakes.
This is coming under which chapter? Chapter 7.
This is miscellaneous chapter.
54.
55. Power to rectify apparent mistakes.
Clerical or arithmetical?
Clerical or arithmetical mistake in any order passed by the government or any other authority under these rules or any error arising therein from accidental slip or omission may within 6 months from the date of issue of the order be corrected by the government or the authority as the case may be. So they admit it was an error which was committed by the previous Tehsildar which came to light. And they ought to have come, there is no quarrel with the source. They also admit that this source was put to auction earlier and it was quarried. and the same source have been put to auction again. There is no difficulty in identification of the source. It is just that the plot numbers were wrongly given, and that needs to be corrected.
Yes.
And the petitioner being an MSME unit, he has a downstream stone crushing unit. So well, it's entirely dependent upon sourcing of the stones. I am now, the MSME unit stands closed because of this difficulty balance.
Yes. Anything more?
That's all. And there is one judgment of this honorable court which says that what mistakes can be corrected. That I have already, that's already on record. It's writ petition number 15700 of 2020 would be there in the report. Saket Kumar Agarwal versus State of Orissa.
No, not in this situation. Other.
Right. This is also reported in volume 131, 2021, CLT page 53 and 2020, volume 2, OLR at page 55, 1055. May I pass on this judgment? Your Lordship may see paragraph 9.
On the word mistake.
What can be corrected? That and my lords, I've shown the relevant rules. No? Now, my lords, one more thing I would just like to show to your lordship is the last order of this honorable court in this case, which is dated 23rd of April 2025. This honorable court, after hearing, had formulated this. The only thing
I have seen the last order.
Yes. So basically, essentially, what the court wanted to know is there an enabling provision in the statute which provides for making
sales?
Let's say kindly have a glance to the order dated 5/11/2024.
Oh.
Yes.
Right, that order, Millard, we were directed to refund that amount.
It was not, the court never directed. Look at the language. Never directed. It says, let the counter affidavit be filed on behalf of the state. In the counter affidavit, it must be specifically mentioned as to whether the opposite parties are inclined to refund the amount deposited by the petitioner for grant of lease. Pursuant to the notice dated 2/1/2023 issued by Tehsildar. In the facts of the present case as asserted, the court may consider issuing direction for refund. May consider. It does not talk about that the direction is for refund.
Thereafter, we filed the counter affidavit, Millard.
Yes.
That is counter affidavit.
And then you say, I am agreeable to refund.
Yes, Millard. Thereafter,
So we are considering whether we should direct the refund or not.
Millard, thereafter, Millard, we sent the demand draft to the petitioner. He didn't accept.
Who refused to accept?
Yes. And now, Millard, so far the fact of the case is concerned, let's see, may come to the annexure 1, that is the advertisement.
Mistake apparently by you.
Yes. Not only
He
me.
is saying is a very simple question he is putting here. He's saying that, yes, there is a mistake, no doubt about it.
But there is a
Whether this mistake is of such amplitude that it cannot be corrected.
Milord, my humble submission is that Milord, it cannot.
He says that Rule 54 permits or empowers you to correct.
Milord, my humble submission is that Milord, as per this Rule 55, Milord, it cannot be corrected. Before coming to that, Milord, it is not.
Why it cannot be corrected?
Milord, I am coming to that. Milord, it is not a clerical error. It is not an arithmetical error. Here,
What is the error?
Yes, sir. Here, Milord, it is not an order evening. It is not an order evening. Milord, if annexure 1 is to be looked into, Milord, specifically plot number is put, khata number is put, Milord. Annexure 1 towards the schedule, that is in ODM. Plot number 78 is put to auction. Thereafter, it was found that no material is available there. And the source, that is plot number 61, what my Lord Senior is submitting, Milord, that was not put to auction, Milord, without hitting the source into auction.
He is already operating there.
He was operating, Milord. He was operating.
His crusher units and all, everything was
61.
The Tesla has said that he has been operating from this number. And since many years, the mining activities or query activities are done at this plot.
Plot number 61. Yeah.
Sure. So the plot number 78 is a mistake.
Milord, now the auction notice source, Milord, it is not mistakenly put. Thereafter, when the survey was conducted, it by satellite, it came to the knowledge that it is a source is not there. Now, Milord, if this auction notice is to be gone to at serial number 2, at serial number 2, it was the duty of the petitioner also. At serial number 2, Milord, annexure 1, it was the responsibility of the petitioner also to verify. That was in Odia, Milord, whether গচ্ছিত ଥିବା খଣିজ ପଦାର୍ଥ ଅନ୍ୟାନ୍ୟ ଆନୁଷଙ୍ଗିକ ସୁବିଧା ସମ୍ପର୍କରେ ପର୍ଯ୍ୟବେକ୍ଷଣ କରି ଲିଜରେ ଅଂଶଗ୍ରହଣ କରିବେ. They have to take part after verifying that whether it is in existence or not.
He has the mechanism verified from satellite.
No, Milord. But from the and after verifying that, he participated with the auction.
Because the impression is given that it is in respect of this plot.
78.
Or
78.
It was clearly mentioned in that notice, 78, not 61.
That was a mistake because there is no 78.
Well, 78 plot is there.
No. It's very clearly.
Let's see, kindly see
it
that.
is not a source. It is not a source. It cannot be.
Their document, they have annexed the map.
Your document?
Yes.
Your translator has signed this.
At page 28.
Agreement is
78.
you have signed.
Yeah, the 78.
You have signed.
Have you put the another option with 61 or something?
No.
Why?
Now, Milord, here the question arises, Milord. Now the 61 is to be put to auction. That's why we are cancelling that.
No, that's why I asked. Have you
No, till now we have
no option?
No, till now we have not proceeded because the matter is pending. If
There is no entry order. There is no entry order.
Now, Milord, if we have to put 61 to auction.
How many,
they have to
participants were there? Oh, he was already adjudged as a successful.
Yes. That is the predicament.
What predicament?
And Milord, if so far this correction of plot number is concerned, Milord, entire district survey report is to be corrected.
What are you talking about?
Because in
not survey report, why you will in the advertisement you will simply put in that 78 is wrongly given, it should be given as 61. That's all. Khata number will go. Here I find the khata number is different.
Now the auction is over.
He's the successful bidder. What over? You have executed an agreement in his favor, collected the money with a smiley face. What to do?
We return the money.
Page
Even-
67, page 60. Landing crossing the local fund, that's what.
That's the source.
Yes.
Tadwala 1 and Tadwala 2. There is no confusion that Tadwala 1 and Tadwala 2 is what is being bidded for.
There under 1 and 2 is stated under plot number 78.
78.
And there is no source.
Whose signature? At the end?
Tahsildar.
Does-
And will
So-
the area is 5 acre. Milan.
552.
Right. Therefore, Milan, we are proceeding. We propose for face auction, Milan. You may participate.
Yes.
And 78 is not a source, is also borne out from that letter, Annexure 11 at page 85.
No, that I have seen.
Thick vegetation and forest growth. That is not a source at all.
Where is your representation?
That matter says Annexure 9 at page 83. Annexure 9 at page 83.
83. Did you not decide it?
Yes, Milan. The annexure 12. That is the decision of the collective.
Then what is the decision?
Yes. That's not, it has not given me this.
Go back. Because we have raised this question and we can correct. Nothing has come.
Page 86 of the concluding line, they have clearly admitted the wrong plot might be due to erroneous demarcation as plot number 78 done by Revenue Inspector Landini.
Presumptive motion. And 76, page 76 is the authorities. They are saying, Tadavara, toll queries 1 and 2.
As situated in plot number 61 and 32.
61 and 32.
Instead of plot number 7.
Same.
Other numbers.
Thanks.
No,
From the bits, when only from here. Next Wednesday. From here. Yes, yes, ma'am. So dedicated for hearing, no difficulty. So come prepared with the short notes in all the matters that will really ease out the disposal.
Highly
With
obliged.
short notes.
Highly obliged. Your lordship has adopted because this was what we were.